Bridgewater.
Good afternoon, Your Honor.
Good afternoon.
Afternoon.
Good afternoon. I see a new face from the solicitor's office.
I am working for the solicitor's office today, Your Honor.
Okay, great. Good to see you.
It's good to see you too. I'll be having this.
And Miss McLeod, and who else we have? Hi, Miss Wright. How are you?
Hello, Judge. How are you?
Good. Who else do we have with the state? Are you by yourself, Miss Sears?
No, we have Miss
I'm on, Your
Allen
Honor.
is present. Yes.
All right, Mr. Pierre Thomas. Good. Okay. Making sure everybody made it back from Christmas.
We had second thoughts, but we decided to come on in.
Decided to come on in. I hear it. We have no choice.
Yes.
All right, you all, let's see. Where's courtroom 2 at the jail? I don't see them on yet. I see ACDC.
I'm sorry. While we're waiting on everyone to get on, the reset date for the SAP calendar is to be January the 9th, 2025.
All right, 2025, January 9th.
Good afternoon, Judge. Whenever you're ready, we can start here at ACDC.
Oh, we're going to start there? Okay.
If courtroom 2 is not ready.
All right. Hello, Miss Allen.
Good morning, Your Honor. Hi, Mr. Thornton.
Good afternoon.
I mean, I get okay.
I know. But normally we say good morning.
Oh, hi, Allen.
How are you? Who are you here for, Mr. Thornton?
I've got Sabrina Lopez, Lopez. How are you, by the way?
Good, good.
Great.
We will have someone send you a chat message, see if there's anything you need.
Yeah, you can send me money, but okay.
I know.
I think what we need right now is a bond. So I just got involved in it, so I don't know.
All right, if we're ready to begin, I'll do my opening. Ladies and gentlemen, we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested for certain misdemeanor offenses. Soon after their arrest, the cases have been the cases have been accused by the Solicitor General's office and bound over to the state court. And nevertheless, this is usually the defendant's initial appearance before a state court judge. So we are able to handle certain matters such as bond, arraignment, and a possible plea offer if one has been made by the state at this juncture. I'll also be providing you with that SAP reset date for January the 9th, 2025 for those who don't make bond. And that will be the date. I want to begin also by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. So govern yourselves accordingly. I'm going to remind the defendants that you have certain constitutional rights. The first being that you have a right to representation. So you should know who your attorneys are by now, and you should have spoken to them. So follow their lead. You also have a right to remain silent. Remember that anything that you state about the facts and circumstances or the occurrence of your case can and will be held against you. The state is here and they are listening. Let's see, who do we have first? ACDC?
Good afternoon, Judge. This is position number 16, Lopez.
Okay.
Okay.
So Mr. Thornton, we're going to get you in and out today.
I appreciate it, Judge. Thank you very much.
You're welcome. All right, this is 24 CR 008307F. Sabrina Lopez, charged at 1 count of battery family violence. Pretrial?
Second, 2017 DUI conviction, level 1.
Okay. All right, state.
Your Honor, the brief alleged facts of the case, the defendant grabbed the victim, who is her mother, by the throat and threw her to the ground because the victim would not engage in conversation about unpaid rent. These events occurred at their residence. where they both continue to reside. We are asking for a $1,500 signature bond, no violent contact with the victim, domestic violence intervention while she is on bond, and no drugs, alcohol, or weapons while on bond.
All right, what is the incident address?
4654 Greenbrier Trail, Southwest Atlanta, Georgia.
And you didn't, I don't know, did you say the victim's name?
Her name is Micella, or it's Micaela, last name Lopez.
Okay. All right, go ahead, Mr. Thornton.
Your Honor, we'd ask the court to follow a recommendation relative to the bond that will allow her to sign her own bond. This is her mother that has moved in and out of her. Ms. Lopez, that the accused, is the owner of the property. As I understand it, Ms. Lopez, the mother, has moved out. She's moved in and out, and she has some chemical dependency problems, as I understand. So, my client works. She has to go to work tomorrow. And we'd ask, I don't know if the court has authority or jurisdiction to remove the mother from the home, Marcella, so that this won't be a reoccurring event. It is my client's home. And we have no objection to the other terms as set forth by the solicitor.
All right. So with the new jail bonds, or the new bond restricted cases, we can't do a straight SOB jail on battery family violence. That must go through the pretrial services.
Yeah.
And so I don't have a problem granting the $1,500 signature bond, but it would be through pretrial, and that's level 1, which is, I think, once a month call in or once a month visit pretrial.
Okay.
And then did you all talk to the victim at all, State?
We did, Your Honor, and the victim wishes to have no violent contact. She is still in the home, and we would ask that you not follow the defense's request to remove the victim from the home. She hasn't done anything wrong. She's actually the victim in this circumstance.
But I guess my concern is this is less than 24 hours, give or take. And I don't want to send them back to a situation where they'll have to call the police again, or I don't want I don't know if there's been an ample cooling down period. And if the house is deeded in the daughter's name and the mother's staying there, I normally don't put the victims out, but I'm concerned about future problems.
Well, then we would ask that there be a total stay away from the incident location. Because, I mean, Your Honor, I understand the court's concern, but how do we create a position of housing insecurity for a person who has contacted the state and asked for help after an alleged battery?
Normally,
I'm sorry, go ahead.
I don't know who's interrupting me, but who's talking that
It's
I can't
Miss
see?
Lopez. I don't know how to work on this. I just want to say
hold on. I haven't given you permission to speak.
Okay, I'm sorry.
So please hold on. And first I need to ask you, do you wish to address the court today?
Yes, ma'am.
All right, I'm going to swear you in first. Raise your right hand. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am. Yes.
All right. Okay, put your hand down. And your name again is?
Micaela Lopez.
All right. And do you reside in the home with your daughter?
Yes, ma'am.
And what is your age, ma'am?
I'm 56 years of age.
All right. And how old is your daughter?
She just turned 39.
All right. And whose house is it that you all are residing in?
She just recently purchased the house. My friend helped her sign for the house. he's given me permission to stay there until I find another place, because he is on the house also. But I work second shift. My daughter and I don't necessarily see each other than the 2 days that she works from home. I'm just asking that there just be no violent what she had spoke of with the no violence. I also asked about the counseling thing. I do not want to press charges against her. I've been in the system and I know what it's like. My daughter's going through something. I don't know what it is. This has never happened before. I'm just asking that I just be able to get back and forth to work and to just continue to look for. I'm trying to be out of there by no later than February. So I am looking for a place to live. Right now, I'm in Delaware, spending some time with my mother. I would like for her to get a signature bond because she cannot afford to have the, bond. So I do not want my daughter to go through what I went through. I think this was punishment enough for her. I do not want I just want peace, and I just want to be able to get myself back to where I was before I moved in with her. We thought this would be something that would work out for the both of us, but it didn't work out.
Okay, so are you stating that you're going to be, or you want to live there temporarily until
just until
February?
I get my place? Yes, ma'am.
I don't know. Can you all do that peacefully?
I can do that.
And you said the house is in your daughter's name and someone else?
Yes, my friend.
And I don't know if I heard Mr. Thornton. What type of work does the defendant do?
She's an analyst with ADP. I think that's a payroll company, is my understanding. And along those lines, I'd like to ask the senior Miss Lopez if she's employed. And I understand she's out of state right now.
I think that's what she just said. When are you returning to Georgia, Miss Lopez?
The 2nd of January. I'm here with my mother.
All right. Do you work?
Yes, ma'am. I've been with my job almost a year now. And I work in Alpharetta and reside with my daughter in Atlanta. I had my own apartment for a year, and we made a decision together for me to move in with her, thinking it would save some money, but it turned out to be a conflict of interest with this situation. So I didn't want to leave my place, but I wanted to help her out as well. She wanted to help me out, but I don't feel like it was a helping out situation. It turned our relationship around, and I don't like that at all. Her and I had a very close bond with each other. I don't know what happened. I just want to resolve this and move on. That's all I want.
Sometimes you can't live with family or friends sometimes. And we understand that, but I just want to make sure that I'm not, even though Miss Lopez has been charged, and there's still accusations at this point or allegations, I don't want her to be homeless. I mean, where would she stay?
Sabrina or myself?
Sabrina.
Well, she wouldn't be homeless. And like I said, I'm trying to be out by the 15th of January. She got upset because I wasn't, because I wouldn't answer her text messages. She was being very demanding and not nice. And then she was being nasty with my cats. I have 3 cats. So I have to find a place where we'll accept my cats. So that's this is where all this went to.
Okay, so now is it January 15th or is it February 1st?
I'm trying to be out by January 15th, but I said no later than February.
Okay.
By the beginning of February, because I don't know how long it's going to. I've been working on it consistently, but with the holiday happening, I've been going to different apartment complexes, and I'm trying to get closer to my other daughter because she just had a baby. So I'm trying to be back in the area where I'm closer to work and stuff. So
Okay.
that's what I've been doing this ever since I was doing this before any of this happened. So I was already looking for somewhere to go.
Okay. So you're asking to stay in the home for another 30 days or so until you can find alternative housing and you believe you all can live there peacefully?
Yes, ma'am. I come in, I don't get there until after 12 o'clock midnight every night. And I sleep until at least 11 o'clock. Between 9, the earliest I get up is 9 o'clock. The latest I get up is 11 o'clock. By the time I get up, it's time for me to get ready to go to work because it takes me an hour to get to work. So, like I said, Thursdays and Fridays, that's the only time her and I would see each other.
Okay.
If we were to see each other. I'm just trying to get out. There is not going to be any conflict. I don't want her to be any longer in there. I don't want her to have to pay a whole bunch to get out. I just want her to be able to move on and me to move on. And hopefully we can get back our relationship like it was. But until that time, it's going to take some time for this. I just want to get back to life again.
All right. Well, she's not going to have to pay a bond. I'm going to agree to a signature bond through pretrial, but I guess we can try it and see what happens. Since you're going to be out in about 30 days or so, is that right?
I think
Yes.
my client wants to say something, and I'm not certain. We don't have a breakout room, but I think she would like to say something. Is that right, Sabrina?
All right. If you give her permission to,
Yeah,
I'm
yes,
not,
I think
yeah,
we're under the circumstance. All right.
go ahead.
I work from home, and I don't want any contact with my mom. It's not going to work. She's
You don't
very
think it
emotional.
will work?
It will not. She has interrupted me while I've been working, and that's why we're here today where we're at, because she is very emotionally unstable, and she goes in and out, and she does not respect my workspace at home.
Okay.
Yeah, can I inquire of the senior Miss Lopez how long she's lived there and where did she live previously?
Yes, you can.
I lived at 128 at Manchester Mansell Apartments for a year by myself. I let my daughter move in with me while she was buying the house for 4 months, and she did not pay me any rent. I had a temporary job that expired, and I managed to pay my rent and my utilities while she lived with me without paying any rent. The exchange was for me to have her couch. She only owed $900 on her couch. So I allowed her to stay with me. And then in this process, she told me, Mom, you move in with me so that way you can save up money and stuff. Well, she got her bills paid up, and I wind up having to put money in a car and stuff and do all this. Now I'm trying to give her, where she doesn't have to have this, like what happened to me in the past. So with her saying I have never disturbed her while she was working. I've never disturbed her. And she's saying this because of her.
Your Honor, I think we've heard
Yeah.
enough. At this
Okay,
point, nobody
but
should be forced to have contact with anyone else. We would agree that there should be a one-time escort, and Senior Lopez can get her things with the help of her daughter and other family members. And these folks need to have no contact. Perhaps daughter Lopez can spend some time away while mom is moving out.
well,
Right.
I don't have anywhere to
Ma'am,
go.
that's enough. Thank you, ma'am. Thank you.
Nothing
Right.
further.
It seems like, and you have another daughter that lives here in Georgia?
With her family. She has 3 children and her husband, and her house is full, and I don't have anywhere else to go. Like I said, I don't communicate with my daughter, but my friend is part ownership of that house, and he's given me permission to stay there until I got my place.
It sounds like somebody needs to file something civilly to deal with this.
Yes.
We would be setting this defendant up for failure if we require
Right.
her to have contact with someone that she's currently sitting in jail for assaulting.
Well, she assaulted me,
Ma'am,
ma'am.
that's enough. Thank
Okay,
you.
well,
Thank you.
I'm just saying, she assaulted me.
Your Honor,
I
Hold
gave
on.
her.
This is not the
testimony that we
trial.
see
This is not the
Okay.
right
trial.
now.
Yes, I understand. I understand.
So what I'm trying to get at is, will the defendant have somewhere to stay for 30 days if we give Miss Lopez, the mom, 30 days to move out?
I don't think so, Judge. It is her house, and I think she's invested her resources in the acquisition of that house. It is her house, and I think Miss Senior Lopez has one of the things that she has not paid her fair share for rent there for the time she's been there. So my client is working every day, but she doesn't have those kind of resources that will afford her to live someplace else. And she has an 18-year-old son, as I understand, who lived there with her. So the resources aren't there. I think Miss Senior Lopez has another daughter, and she has friends who are giving her permission to live places. I think it will be, and she's hadn't been there that long, as I understand. I think she should be able to, as suggested by the solicitor, if she could get an escort to get her things, would probably be the best, because we don't want to be having this hearing again and again. I don't think.
Right. It's just normally, legally, we don't put the victims out. It's usually the other way around. But in certain circumstances where the victim is just staying there and doesn't, I guess, have a legal right to be there, and I don't want to dive too deep into that. Sounds like a dispossessory matter to me. And it sounds like she may have options. So I've said the $1,500 signature bond through pretrial. And Miss Senior Lopez, Michaelia, or Michaelia, sorry, I'm mispronouncing your name.
May I just say one thing, please?
Well, I do need to move on, but 1 second. What do you want to say real quick?
I just want to say, I do want to get out. I do not have anywhere else to go. I was talked into this, to do this, to help her out, to get on top. For her to do this to me, and she knows I don't have anything. I just want to get a place. I'm getting out of there. I will not be in her place. I work 5 days a week. I just want you to know that I'm getting out. So
I understand, but what are we going to do in the meantime?
I'm
We don't have a plan in the meantime.
What I'm going to have to do is just try not to be there. She has a boyfriend that she stayed with for 3 weeks now. He lives right down the street. So what I'm just
if I may organize for the court just a bit. What we've heard today is that the allegation is that the defendant grabbed the victim and slammed her to the ground.
Right. Yes.
Miss Lopez, please mute yourself.
Okay. All right. All right. I'm muting.
Her to the ground, based on her unwillingness to have a conversation. That's what we generally do when we have disputes, is we discuss them, but we end up here before Your Honor when it becomes violent. And that's what's happened. And now the defense is misrepresenting that the victim in this particular case has somewhere else to go, and has urged this court to put the victim in this case out after she's been allegedly assaulted, after she's done what you're supposed to do when you're allegedly assaulted, which is contact the police and ask somebody to make right of this situation. Making right of this situation is not asking Miss Maciela Lopez to move out of anywhere. That is for a dispossessory. That is for an eviction process. That is not for this court to decide. This court should be deciding whether or not Miss Sabrina Lopez meets the standards for bond. Now, she does meet them, but removing Maciela Lopez from a home does not mean that all of a sudden Sabrina Lopez is going to follow the orders of the court and not commit any other offenses. Now, if she has unmuted herself and made witness before this court that she doesn't want to be around somebody because it's not going to work, that should be telling to Your Honor that she has no intention of abiding by law. That she fully intends that to allow disagreements to turn into something more than disagreements. So I'm asking Your Honor to impose a signature bond. and to not put Marciela Lopez out of a home, to give her time to find someplace else to be. She's testified before this court under oath that she will find someplace else to be by February 1st. She has pets. That's clearly when people are in domestic violence situations and they have animals, it's always very difficult for them to find someplace else to live. And especially difficult for somebody to find someplace else to live at this time of year. So to ask her to go with a one-time escort to a home that she's known, even for a short period of time, I would ask that the court not make that decision, to give her more time. And if the no contact is what would satisfy the court, then no contact should be appropriate after Marciela Lopez finds someplace else to stay. And Sabrina Lopez should find someplace else to be it Fulton County Jail or otherwise in the meantime, if she can't keep her hands to herself.
Last thing, Ms. Lopez, and then I do have to move on. We have a large calendar today. Quickly.
I've had a very abusive background with my mom, and I've done a lot of therapy because she was on drugs for a long time, and she mistreated me a lot. I was trying to help her. I'm not saying I'm going to put my hands on her. I do not plan to hurt her. I just know that I work from home, and again, I stress that she has interrupted in the past, in which I have tried to talk to her. I've talked to her multiple times. I am just afraid of, because of our past, I don't want any kind of altercations at all that will chance my job. That's all. I do not have no plans of, I don't want to hurt my mother whatsoever. I just don't want to issue with my work. I work from home.
Okay. So here's what I will do. 1,500 signature bond through pretrial level 1. And I'm going to give Miss Senior Lopez 30 days to, she's saying she will move out 30 days or sooner. Normally, we do not have the victims to remove from the home, even when their name is not on it. So I do have to go with what our parameters are here. Speak to your attorney. There are other avenues that you can take to have her put out or evicted from the home, which is not my parameters for today. But hopefully she will get out sooner than later. But I'm going to order no further violent contact. And it goes both ways. Mom is not to have any violent contact with you. You're not to have any violent contact with her because you will be on bond. And part of the bond conditions with no further violent contact or, no drugs, alcohol, weapons, or guns while you're on bond, and to not, have any violent contact with your mom. I know you all may have helped each other out in the past, but obviously that is not going to be for the, for the future. And if you want to stay somewhere else until she moves out, you're free to do that to protect yourself from not coming back down to the jail. But we will have to give her that time to stay there for her to then move out and find another place, okay? And hopefully it will go without incident again. Anything else, counsel? Did I leave out anything?
Judge, is that to February 1st or 30 days from today?
Well,
Today's
actually,
the 29th.
oh,
Yeah.
well, yeah. I guess she said January 15th. First she said February 1st. Then she said January 15th.
Would the court entertain a compromise of setting the date at January 15th?
Yes.
Thank you.
All right. Anything else?
I think that's it for me, Judge. Thank you. And Ms. Burke.
Did Your Honor also impose a domestic violence intervention program while on bond?
No.
I don't remember.
Yeah, no, I don't. I don't normally do that. I wait till the case gets a little farther along. I don't usually do that. I don't know if she'll be able to afford to do that anyway. So we'll breach that later. Although there, the only thing through pretrial for free would be a anger awareness or something like that. And she can maybe do a 1 or 2 day course through pretrial. I don't know if she needs it or not.
State will request such.
Okay, they have a free class. And I will just ask her to take a 1 day anger awareness class through pretrial. They'll give her the information and it's free. And just 1 day in that class, okay?
Fine.
That'll help. All right, that is it.
Thank you, Judge. And
All right, thank you.
all right.
Your Honor,
Yes.
in courtroom 2, they're gonna need their rights read to them. And just a FYI, we have a code red that's about to happen. So I want to try to speed this up so we can at least get all the cases.
Boy.
Exactly.
Okay,
Thank you.
thank you. And who do we have next? ACDC?
No, forum 2, but after you read the rights.
I didn't hear you.
Forum 2, but once you read them their rights, we'll go to position number 7.
All right. The defendants in courtroom 2, you have a right to representation at this time. So you should know who your attorneys are and have spoken to them. So please follow their lead. You also have a right to remain silent. And remember that anything that you state about the facts, the circumstances, or the occurrences of your case can and will be used against you. So follow your attorney. All right. And who is this that we have?
Number 7.
Number 7.
Judge, it's a first arrest level 1.
Thank you. 24 CR 008312C. Tamara Culverson, 1 count of disorderly conduct. And this is her first. Go ahead, state.
My apologies, Your Honor. I was muted. This is a co-defendant case, I believe. I mean, for the sake of efficiency, we might want to do the co-defendant at the same time. Is that possible?
We can ask courtroom 2. Who's the co-defendant?
Co-defendant.
Yes, they're both in forum 2.
Stand on this side. You stand on
It's
this
Miss Glass, I believe.
Glass. Okay.
Glass, she's my client.
Okay. Thank you, Mr. Cloud.
Deanna Glass.
All right. That's 24 CR 008300C. Same charge, disorderly conduct.
First arrest level 1.
Good. Same thing.
All right. As it relates to Miss Culverson, Your Honor, the brief facts of the case is that on December 24th, the officer was assigned to 844 Cleveland Avenue, East Point, Georgia, which is a Walmart location. Basically, 2 females started to have a verbal altercation inside. The officer was asked to put them out. The Walmart associates kicked both parties out and canceled their transaction. After both parties exited the building, they continued to cause a public disturbance in the parking lot. I believe it was said that they were throwing punches at one another, causing a physical altercation, at which point people began to pull out their cell phones and the whole matter and record the incident, and the whole matter created a lot of chaos. The recommendation from the state, given the charge in this case and given what the representation of the criminal history is a signature bond through the jail, no alcohol, drugs, or weapons, a stay away from that incident location, which is the Walmart, no further contact with the cross defendant in this case, and the completion of an anger awareness course. There is nothing further to add from the state, as this is a cross defendant case.
Your Honor, we'd agree with that.
All right. I will order
For Miss Glass, Your Honor, we are in agreement with that, those conditions.
and that would be for both, correct, Mr. Pierre Thomas?
I do believe so.
Because they both are first.
Yes.
Okay, I do believe so. In the interest of fairness, I do believe so.
All right. So are they strangers, I believe? Sounds like
Strangers, Your Honor.
Okay. So they are strangers. All right. So we can do that. 1,500 signature bond for both through the jail. No further contact with each other.
That's fine, Your Honor.
And to stay away from the Walmart on Cleveland Avenue. Both of them should not go to that Walmart. No drugs, alcohol, weapons, or guns while on bond.
Thank you.
Thank you, Your Honor.
All right, thank you.
What was the bond amount?
12 minutes.
Next, I'm not sure. Next, we could go to position number 18. Mr. Penn?
18. This is Torell Penn, 24 CR 008319J. 2 counts of simple battery family violence.
This
Pretrial.
is his first arrest, Your Honor.
Yeah, okay,
Good.
yeah.
All right.
This is the incident that happened on the 25th at 8 in the evening. The 911 caller is the daughter of the victim. His name is Jermaine Rolls. She called police and said there was an emergency on scene. She directed police inside and said, please hurry. Her dad and her cousin were fighting downstairs. Police entered the location. This is 3046 Eleanor Terrace, Northwest, and they observed the defendant, Mr. Torell Penn, and Mr. Jermaine Rolls in a physical altercation. Police witnessed the defendant multiple times punching Mr. Jermaine Rolls in the head and then kick him in the head once while he was on the ground. Mr. Rolls reported that there had been an argument because he was disciplining his daughter and told the defendant to mind his own business. The defendant in front of you, Your Honor, is 17. In response to being told to mind his own business, the defendant started swinging on his uncle. We have spoken to the victim in this case, Mr. Rolls, that's Roles. He reports that they have been living together at the location and he confirmed what happened. He says nothing like this has ever happened and he's planning on leaving the location. He does not wish to have contact. If you would sound for Mr. Rolls, Your Honor, we are asking for a $2,000 signature bond through pretrial, no drugs, alcohol, or weapons, and no contact with Jermaine Rolls. Thank you.
All right. Is Mr. Rolls on the Zoom call?
He will need a one-time escort if he has not left the location. So we'd ask that the bond order state that Mr. Penn can return home if that's his residence and he intends on returning there as long as it's verified that Mr. Rolls is gone. He may need to do that with law enforcement.
All right. And Mr. Rolls is not on the Zoom. Okay.
Your
All
Honor,
right.
are you going to entertain a cosigner requirement? This young man's 17.
Hadn't heard that. He's 17.
Yes.
Yes.
And
who's representing Mr. Dotis?
Your Honor, that'll be me. I'm ready to go when you have a moment for me.
Okay, go ahead.
Thank you, Judge. Yes, we're in agreement with the signature bond request. I do want to clarify if the prosecutor could confirm. Were you asking for Mr. Penn to leave the residence, or did Mr. Rolls say he was going to?
Mr. Rolls' plan is to leave the residence.
Okay. Okay, thank you. I just wanted to make sure I clarified.
Absolutely.
Yes, Your Honor. In the meantime, I did discuss this with Mr. Penn. Until we have confirmation that Mr. Rolls is gone, he can stay with his older sister, Jasmine Penn. She is 26 years old. Your Honor, if a cosigner is needed, I don't believe pretrial requires one anymore as of last week. I can't remember the exact date, but I do remember an email going out. So I would ask that there be no cosigner, but if Your Honor does want one, we would ask that it be Jasmine Penn that signs him out. And again, Mr. Penn is fine with no further contact. And if we need to do a one-time escort to ensure that Mr. Rolls has left, that's fine.
I guess my concern is he's 17. He's not independent. I don't even know if he has a license and can drive a car. So putting him out bond by himself concerns me.
Right. So he is staying at that location, but I do understand that his older sister is helping him out as the kind of adult in his life. And Your Honor, he is a high school student at Frederick Douglass High School. So we want to make sure that we're not holding him back from getting back to school in a couple of weeks. And my understanding is that the whole family will continue supporting each other at that residence once Mr. Rolls is out of the picture.
And that Mr. Rolls is his uncle?
It's his cousins. I don't know if it's her father,
cousin.
stepfather.
I believe the young woman that was being disciplined is the defendant's cousin.
Okay.
Your Honor, we'd request an adult cosigner. if not a curfew and the requirement that you go to call a high school.
Well, I usually do those requirements anyway. So I would certainly do that. And so Mr. Dotis, are you going to talk to Ms. Penn about being the co-signer?
My understanding is that Miss Penn can co-sign. I have not, because I was not able to interview until we started court. I haven't been able to confirm with her. I'm happy to do that and readdress.
Okay.
But
Okay.
I would just again request no co-signer, but I do understand the court's position.
Well, he's still in high school. I'm going to request a co-signer, and if you could check with her in between court and let me know if there's a problem. If you don't say anything, I'll know that it's fine. And we'll put her down as Jasmine Penn. And
yes, and I can put that spelling in the chat. I believe most of my cases are at ACDC, so once we finish up, I'll hop off and give her a call.
Okay, yeah, put that in the chat, and then I will order the $2,000 signature bond. That's $1,000 on each charge through pretrial services, level 1, and the victim Jermaine Rolls, as he's gone from the property. That's fine, but when Mr. Penn gets out, he should have a police escort to return to the property. They will sweep the property and make sure that Mr. Rolls has left, and somehow determine that he doesn't have any more items in there, and that they will be able to assure law enforcement that Mr. Rolls has moved out of the property. If he hasn't, then the defendant must wait until he's moved out completely before returning to that property, I guess, and stay with his sister, Jasmine Penn. No drugs, alcohol, weapons, or guns while on bond. And I'm going to order a curfew at 10 p.m. to 7 a.m.
And Your Honor, I would note that Mr. Penn is looking for work. I don't think that would interfere, but could we have something in that curfew order allowing him to work if needed?
I guess so. I'm concerned. I'm going to tell him he needs to graduate from high school.
Right, and he is planning on doing that.
Okay, and enroll in a GED program if he doesn't graduate immediately. But if he's on track to graduate, that would be my first priority, would be honoring the curfew to do homework and graduate from high school. So if he has to work, be out and make an extended an hour on each end in order to allow him time to get home. But let's breach that when we get to it if we have to. Right now, we're going to focus on school and hopefully not get in any more trouble.
Thank you, Judge.
Thank you.
Your Honor, if we could go to the next co-defendant case, position number 4. That's Mr. Campbell.
Okay.
First arrest, level 1.
Good.
Brief facts of the case, Your Honor. One moment. Let me pull it up.
That's 24 CR 008310J, Kevin Campbell.
That is correct. And are we doing his co-defendant at the same time as Ina Brown?
Think so.
All right. Brief facts of the case on Mr. Campbell. And by the way, their history is similarly situated as well as just like the other 2 co-defendants. On December 24, 2024, the officers responded to a domestic call at 2135 Godby Road, apartment 40-735. The officers quickly learned that the male and the female had been in a verbal dispute that turned physical. The officer was unable to ascertain who was the primary aggressor because their stories conflicted and they were both taken into custody. The 2 are boyfriend and girlfriend and have lived at the location for some whiles. Both sustained minor injuries to their person. Mr. Campbell had several scratches on the left side of his face and a scratch to the left side of his torso. Miss Brown had a minor injury to her bottom lip and a scratch to her ankle. Photos were captured. The officer glanced at the apartment and noticed that there was vandalism from the 2 fighting. The recommendation from the state, Your Honor, given the cross defendant status, is a signature bond through the pretrial services, no alcohol, drugs, or weapons, no contact with the victim. I don't know who will have to stay away, but one of the defendants will have to stay away from the incident location and the completion of an anger management course. And that is the same recommendation for both, because all indications are that this is both of their first arrests. Nothing further to add from the state at this time.
All right. And who wants to go first? PD, right?
Yes, Your Honor. I am not sure who has the name on the lease, but I did speak to Miss Brown. She let me know that she can stay with family. She works from home for a dental insurance company, and she's currently enrolled in a nursing program at Atlanta Tech.
Okay. And I don't think I called Miss Brown's case, but I will. 24 CR 008309J, Ena Brown, 1 count of battery, family violence. Let me do Mr. Campbell first. And who's representing Mr. Campbell? Ms. McLeod? Ms. McLeod? Is she still on? Oh, there she is. She is still on. Oh, Miss McLeod. Did someone call Miss McLeod? Maybe she stepped away.
I can give her a ring, Your Honor.
Okay.
We have Mr. Dotis representing Ms. Ms. Jones, position 14. She's a co-defendant.
In this case as well?
I think it's just Miss Brown and Mr. Campbell on this case.
I thought this one was Mr. Brown and Miss Brown and Mr. Campbell. No?
I don't have a co-defendant for Miss Jones.
No.
Oh, I'm sorry. Y'all switch out. Come on, Miss Jones. This is Miss Jones. I apologize, Doug.
Okay, we haven't finished the other case.
Unfortunately, she didn't answer, by the way.
She did not answer.
She's
I guess
still on.
Yeah, she's still signed on. Let me at least do Mr. Campbell, but I at least need someone to come back to defend Miss Brown. So with Kevin Campbell, we'll just do a $2,000 signature bond through pre-trial.
Here, I'm sorry.
Oh, okay. All right,
Mr.
we're
Campbell.
doing the co-defendant case with Brown and Campbell. And
Yes.
you represent Miss Ena Brown.
No, Mr. Campbell. I represent Mr. Campbell, Your Honor.
Yes, Your Honor, and I represent Miss Brown.
Okay, I'm sorry, I got them mixed up.
No worries.
And so with Kevin Campbell, a $2,000 signature bond through pretrial. I'm going to order the 1-day anger awareness course. And for him, he's going to do the stay away.
Your Honor, he tells me they're both names are on the lease. It's just a misunderstanding between both of them. They were already speaking by the time they were on their way to the jail. It's going to be a huge hardship for him if he has to stay away. They've been living together approximately 3 years, and my understanding is that both of them do not want a stay away. They want violent contact.
I thought Ms. Brown said she could go somewhere else and she could stay away. Was that the representation earlier?
It was, yes. She is able to go and stay with her family.
Okay, because that's where my client lives, and his name is on the lease. It's going to be a hardship for him to stay away.
Well, it's where they
think
both
Ms. Brown has her hands. They both live there, right?
Well, if Miss Brown is able to go and stay somewhere else, can you shake your head or give me a thumbs up, Miss Brown, if you're able to stay somewhere else?
Staying somewhere else is fine, but working.
I can't hear you. Staying somewhere else is what?
Can you hear me? Yeah, just speak loud. Oh, I'm sorry. Staying somewhere else is fine, but working somewhere else
and going to online school, that's a different issue.
Well, I didn't ask you to work somewhere else. I just want to know, while he's on bond, can you stay somewhere else to cool this down and make sure
But if
that
I'm
they're
on
not going to...
bond, then I have to live and work somewhere else at the same time.
Your Honor, would you consider a no further violent contact instead of a stay away? She does work from home. That is where her work is.
But all you need is a computer and a desk or somewhere else. I don't understand why you would have to switch jobs if you moved.
I think she's saying that it's an inconvenience. Also, Your Honor, this couple, they have been together for approximately 3 years. And, you know, they don't have any history of violence at all.
The third concern is that the cooling off period, this happened allegedly 2 days ago.
I know, but they talked even since they were talking from they were on their way to the jail. That's my understanding from my client. And there was even an understanding that if there was a bond that had to be paid, that her mom would pay it. So they have actually been speaking. They cooled down immediately after they got arrested.
Who called the police?
She did.
All right, I will on Kevin Campbell, 2,000 signature bond through pretrial 1-day anger awareness. No drugs, alcohol, weapons, or guns while on bond. And I will allow him to stay at Garvey for no further violent contact.
Yeah, hand on, Mr. Campbell. If you have any questions, I'll answer them for you later.
All right. Unless he's gonna tell us that he's gonna leave the apartment.
No, I was honestly like,
no, don't
want to hear about the
speak.
facts.
You can call
I just
me
want to know
later.
whether you can stay somewhere else. That's all. If you can't, you can say that, but I don't want to hear about the facts.
no, I don't want to stay. I can't stay anywhere else, but I just wanted to say.
Listen, Mr. Campbell, do not speak. That's why you have a lawyer. Don't say anything.
All right. And so, and then with Miss Brown, I'll do the same thing, a $2,000 signature bond through pretrial. 1-day anger awareness.
What level?
And level 1. Both of them are level 1. I didn't say it on Mr. Campbell's. And both are level 1. I hope you all can go and live in peace.
And you have to put the contact provision, Your Honor.
Oh, and no further violent contact. I'm sorry. On both. No further violent
Your
contact.
Honor.
All right, thank you.
Your Honor, does Miss Brown have a stay away?
No.
Neither of them. They're both no further violent contact.
Gotcha. Okay.
They can
Thank
both
you.
stay there, hopefully peacefully.
All right. Thank you.
Oh, the signature bond.
We can go to position
Yes.
number 4. That's Ms.
Judge,
Wilson.
was it a $2,000?
Who's speaking?
Judge, is it a $2,000?
Oh, I'm sorry, deputy, because I couldn't see and I thought that was someone else. Yes, they're both 2,000 signature bonds through pretrial. I'm sorry.
Thank you.
Next, we can go to position number 24, Ms. Wilson.
This is 24 CR 008322A. Tanae Wilson, charged at 1 count of battery, family violence, 2nd count of cruelty to children in the 3rd degree. Pretrial.
First.
Good.
Okay.
All right. State.
That's my case, Your Honor. Thank you.
Okay.
This is an incident that occurred December the 19th at 7840 Roswell Road in Sandy Springs. The victim in this case is the ex-husband of this defendant. His name is Rufaro Moyo. That's Rufaro. Last name is Moyo, Moyo. He has joined us on the Zoom, I believe. Police were called at about 7:55 p.m. where they met with the victim who was outside near building 100. He was experiencing swelling to his right eye and reported that he was having a hard time seeing out of that eye. He had come to the location to exchange the 2 children he shares with the defendant. One is a 2-year-old, the other is verbal, a little bit older, initials TM. When that child, TM, was asked on scene if they'd watched or observed the defendant in front of you strike dad, they nodded that they had. The victim reported that he had put the children in the car when the defendant assaulted him. He said this is not the first time that there's been violence, but the first time police have been called, and that she's been arrested in this kind of situation. He also reported when we spoke to him today that the incident location is actually in front of the Sandy Springs Police Department. And Your Honor knows that if individuals are having to meet at a third party or a neutral place to exchange children, that's an indicator there's an issue here. The victim is requesting no violent contact. Our position, based on the fact that this is the defendant's first arrest, is a $4,000 SOB through pretrial. Absolutely no violent contact and no drugs, alcohol, or weapons, Your Honor. And if you sound for Mr. Moya, thank you.
All right, Mr. Moya. I don't think he's on. All right, Mr. Doders.
Yes, Your Honor. We have no objection with the state's recommendation. We would note that the parties are, going through a tumultuous divorce. We would ask. I think if it sounds like they're trying with the third part or I think the issue was just the transfer or the custody transfer. We just ask, I guess, as a condition to continue doing it in public spaces. But if he's fine with no further violent contact, we just ask to accept the recommendation.
All right, $4,000 signature bond through pretrial, $3,000 on the battery, $1,000 on the cruelty. And the parties want to, I don't know, at the time of this incident, they were or were not living together, or they were just doing the exchange and got into
No,
a
Your
fight?
Honor. Based on our information from the victim, these individuals are divorced. I did not see any filings in Fulton County as it relates to them, so I'm not sure where that action is out of.
Mm-hmm.
Right.
So they're already divorced.
So we're in the middle.
Hold on, ma'am, Miss Wilson. Let me do my understanding is the divorce is ongoing. I don't have any information outside of what Miss Wilson has told me. I don't know what custody arrangements have been worked out or anything of that nature. Doesn't sound like the alleged victim is on to chime in.
So the victim is requesting no further violent contact?
Yes, Your Honor. No one's trying to change any custody or visitation situation here.
Okay. All right. So we'll just go with the no further violent contact and continue with the, I guess if he wants to continue with visitation with the children to exchange at the police department. But I'll order the no further violent contact, and there isn't a stay away, so that'll be it for Miss Wilson. No drugs, alcohol, weapons, or guns while on bond.
Level 1.
Thank
Level
you.
1, yes, level 1.
Next we go to add-on position number 2, Mr. Moss.
Said 2?
Add-on 2.
Add-on 2, Your Honor.
Oh, I don't have an add-on.
Oh boy.
That's my case, Your Honor, whenever you're ready.
Ms. Bridgewater, you want to read it?
Yes, add-on position number 2. Let me read that for you. This is the case of Maurice C. Moss, case number 24 CR 008326D, charged with battery, family violence.
All right. Pretrial?
Second. Last arrest was possession of marijuana with intent. It's level 1.
Okay. State?
Your Honor, the alleged facts of this case are incredibly violent. The police responded to the residents at 1033 Gun Club Road in Atlanta, Georgia, and they were met by the defendant at the door to the apartment where he lives. he advised that his girlfriend, the victim in this case, Rena Brown, was inside the location. Police could see her behind him at a certain point when he moved and manipulated the door, but he was attempting to prevent the officers from seeing inside of the residence. They asked to speak to the victim in the case, and they were blocked by the defendant. After he was detained, police could see visible injuries to her face and her neck. She had 2 black eyes, scratches to her face and neck. She had trouble breathing and standing, and Grady ambulance responded to the scene. We are confirming what Grady ambulance alleged at the scene was a broken nose, bruises to her back, and a possible concussion. So we would ask for the highest surety bond that this court can impose, no further contact with the victim, and while he is on bond, that he immediately start. I know that this court does not typically request or require domestic violence intervention of defendants until after a case has already been adjudicated. Given the injuries, given the level of injuries in this case, we would ask that he start immediately if released on bond. Of course, no weapons, no drugs, no alcohol, and no further offenses.
Okay. All right, PD.
Yes, Your Honor, it's me again.
Okay.
Mr. Moss is 35 years old. Pre-trial was breaking, my connection was going in and out. I believe my understanding was this was just his second arrest and there was no violent history. Apologies if I missed anything.
No.
Your Honor, I have good contact information for Mr. Moss. He is a lifetime resident of the city of Atlanta. I have a good address for him that's separate from the incident location. And it's an address that my understanding is the alleged victim has no reason to go to. If I don't believe the alleged victim is on, but if it is no further contact, that should be fine. Your Honor, my client is the father of 3 children. He's the primary provider of a 14-year-old, a 10-year-old, and a 9-year-old. He has a good job where he works 12 hours a day to provide for them at Central Truck Driving. Your Honor, he is currently on the clock for this job, and he would be in danger of losing this job if he remains in custody. Your Honor, we are just asking for a signature bond at this time. Mr. Moss does refute all of the allegations. We would ask for the 1-day anger awareness class, no further contact, and anything else that this court would deem appropriate to ensure that there are no further incidents.
But the victim in this case is the children's mother or just a girlfriend or whom?
My understanding is it's just a girlfriend.
Okay. All right, and who's representing Mr. Moss?
That would be me, Your Honor. That's.
Oh, I'm sorry. I didn't mean that.
There's not. I don't believe there's a cross. Yeah.
No. Okay. Sorry about that.
That's it. We've had a lot of cross defendants today.
A lot of cross, right? Okay. Sorry about that, Mr. Dotis.
Yeah. Despite the number of cross defendants on this calendar and the level of this particular case, there is no allegation that Mr. Moss suffered any injury despite the numerous injuries to the victim in this matter.
Right. I'm going to go ahead. I'm sorry.
Numerous severe injuries to the victim in this matter. That's all.
Okay. On this matter, I'm going to order a $4,000 surety bond. And with that surety bond, I'm going to order no further contact with the victim. And I think it was Ena Brown.
Sorry, your honor is R-E-N-A Brown.
Oh, Rena. Oh, Rena. I'm sorry. R-E-N-A. All right.
I believe it may be pronounced Renee.
Oh, Renee. Okay. No further contact with the victim, Renee Brown. No drugs, alcohol, weapons, or guns while on bond, and a stay away. Is that her residence at the 1033 Gun Club?
It appears that they live at that location. We would ask that the defendant not be allowed to return to that location except with a one-time law enforcement escort.
Right. And I'll order a stay away from that location, but he can have a one-time law enforcement escort to get his personal belongings. Stay away while on bond. All right, that should do it.
Next, we can go to add-on number 1, Mr. Hammond.
Your Honor, this is Antonio Hammond's case number 24 CR 008324C, charged with simple battery, family violence.
All right, pre-trial.
First level 1.
Good. State.
Your Honor, the allegation in this case is that a verbal altercation ensued between the defendant and the victim is Kayla Masters, with whom he fathered a child, but that child is no longer with us. The defendant struck Ms. Masters multiple times during the dispute, and when his mother, Ms. Sedaria, intervened, she was inadvertently struck as well. So it's one count of family violence battery. The incident location is 329 Tarragon Way in Union City, Georgia. And these events took place on Christmas Day. Ms. Masters and Ms. Sedaria are both on the call.
Ms. Masters, do you wish to address the court today? Yes or no? I see a Kayla M. Is that Ms. Masters?
I believe so, Your Honor.
Ms. Masters, can you hear me or can you unmute yourself?
Yes, ma'am, I can hear. I'm sorry.
Okay, do you wish to address the court today? Yes or no?
No, ma'am.
All right, thank you. And then, well, her mom, the other one is not a victim, or is it, are
Your
they
Honor,
both the case?
my understanding is that the victim is actually his mother, not Miss Masters. That my client and Miss Masters were having a verbal argument that his mother then jumped on top of him. He tried to get her off of him, and then she threw glass at his face, busted his nose and his forehead. But she's actually the listed victim, not Miss Masters. That's what I read from the warrants. Maybe the state can clear that up, but there's only one. I'm sorry?
And what's mom's name?
I'm not sure.
I think I see her, Sedaria Hammond. Ms. Hammond?
Hello?
Yes, do you wish to address the court today, yes or no?
My son is not
No.
My son did not
No,
mean to
Ms.
do that.
Hammonds. Ms. Hammonds, listen to
Come
me.
on, baby, on my phone, yes?
Ms. Hammonds.
Yes.
Listen to me. First of all, I ask you, do you wish to address the court today, yes or no? First say that. Answer that question. I'm sorry?
No, ma'am.
Okay. You can't say no and start talking. If the answer is no, then
the
mute
other
yourself.
line was clicking, that ma'am. The other line was clicking. That's what I'm saying.
You can mute yourself. Thank you. All right. Is that all, counsel?
No, Your Honor.
Okay.
Mr. Hammonds is 20 years old. He works at UPS part-time. He does have his high school diploma. He does live with mom. He does not live with girlfriend. And he told me that he can go live with a friend, considering how things are with mom right now. But I do want the court to know that it was his mother who threw things at him. We'd ask for a signature bond for him.
All right.
Your Honor, I believe maybe I can provide some clarity. Ms. Wright is his mother is alleged to have thrown some things at him. She attempted to intervene in Mr. Hammond's attack on Ms. Masters. And in doing so, she was struck and thereafter continued to attempt to intervene by throwing glass at him and other objects because he continued to wage an attack on Kayla Masters.
All right. I'm going to, and I did hear you state regarding the injuries and the level of injuries. I'm going to order a $5,000 signature bond through pretrial, and that would be level 1. And with that signature bond, which I'm reluctant to give, I'm going to order that Mr. Hammond's stay away from that incident location, which is Tarragon, I think 329 Tarragon Way in
Yes,
Union
Your Honor.
City.
That is correct.
And no further contact with both Kayla Masters as well as Sedaria Hammonds. No further contact with both of them. No drugs, alcohol, weapons, or guns while on bond. And I'm going to have him to take the 2-day anger awareness course through pretrial. And I guess that'll be it. Anything else, counsel?
No, Your Honor.
Okay. Okay.
Thank you.
Number 14, Jones.
(24 CR 008304E). Shaquila Jones, charged with 1 count of theft by taking. Pretrial.
And Your Honor, she's also position 15 as well. If we can do them at the same
Oh,
time.
she's both. Okay, 24 CR 008305E. Ms. Jones is charged with 1 count of theft by 2 counts of theft by conversion. Okay,
Your Honor.
pretrial.
Fifth arrest, 2013 and 12 probation. 2010 FTA, it's jail is the recommendation.
All right, go ahead, state.
The facts of this case are that the defendant was an employee working at Evergreen Apartments, and she collected rental payments from residents and then converted them to be payable to her personally to at least 2 occasions, to the point of eviction proceedings being commenced against at least 1 resident. These matters came to the attention of the management, and Ms. Jones was subsequently fired from Evergreen Apartments. Warrants were taken for her arrest after an investigation was conducted. We're asking for a $2,500 cash bond on each count. No drugs, alcohol, or weapons. Do not return to the incident location. No contact with the victims.
Well, you said she was fired, but of course we'll order, that she obviously stay away from the Evergreen Apartments. Is that what you're asking, state?
Yes.
Okay.
And she didn't have any reason to return there. She doesn't reside there, and she no longer works there.
Okay, great. All right, Mr. Dotis?
Thank you, Your Honor. Ms. Jones is 45 years old. I believe I heard that the last arrest was in 2013. I've got contact information for Ms. Jones. She's a lifelong resident of Atlanta. She resides in the area. Her address in the booking sheet is correct. She resides with her sister, Kalisha Jones, so she does have ties to the area. Your Honor, she is a mother to one 9-year-old, and she is the primary provider for that 9-year-old. She's also a graduate of Jonesboro High School, and she currently serves as the community manager at Novel Co-working, where she manages office space rentals. Your Honor, at this time, we just ask for a signature bond through pretrial so she can get back to raising her 9-year-old.
And then do I need to decide on this independently of the second case? The two are all of these are the same dates. So it's just that no, it's not. Let's see. The first case is 9/1/22. The second one is 8/19/2022. So they all the three checks or transactions that were alleged to have been converted. Are the facts the same on the second case?
Yes, it's a different resident, but same methodology.
Same method. Okay, gotcha. All right. On the first case, I will order a $4,000 signature bond through pretrial. Stay away from the Evergreen Apartments. No further contact, I guess, with any of the residents there or the rental office. No drugs, alcohol, weapons, or guns while on bond. And with that pretrial services, I guess that'll be level 1. And that will be it for now on the first case. And then on the second case, ending in 8305E, with 2 counts of theft by conversion. That will be a $5,000 signature bond through pretrial, $2,500 on each charge. And with that signature bond through pretrial, stay away from the Evergreen Apartments and no further contact with, I guess, management or any residents at that complex. Level 1 with pretrial. And I guess that's it. Did I leave out anything? Anything else, counsel?
Nothing further from the state.
Not at this time, Your Honor.
All right, thank you.
Next, we have position number 1, Mr. Ackley.
Okay. And thank you. I see your message, Mr. Jodis, on that other case. So that's fine. Good. Yeah.
Yes. Thank you, Judge.
All right. And I'm sorry, Deputy, what did you say? Which number is this again?
1.
1. Okay. (24 CR 008306A), Jericho, Markeith Ashley. Okay. And this is he's charged with 1 count of criminal trespass, pretrial.
17, got open battery out of state court, open trespass out of state court. On probation in Lawrence County, ag assault, ag battery, burglary, another ag assault. 2022 terrorist threats interfering with emergency medical professional conviction. 2016-18 probation, 2011 simple battery conviction. Resident of Warner Robins.
Okay.
The brief facts of the case is that on December 25th, 2024, the officer responded to the location of a possible criminal trespass. The officer met with the hotel clerk who advised that there was a man who did not have a reservation sitting there eating breakfast. The officer made contact with the male and asked him if he had any business at the location, and he said he was about to leave. The clerk stated that she wanted him to be criminally trespassed from the location for future incidences. On the 25th, so I'm sorry, that report was from an earlier time, but on the 25th, the defendant was seen criminally trespassing after having received the warrant at that location. The officer approached and stated that he was no longer allowed to be on the property and re-informed him of the consequences of returning to the property within a year of the criminal trespass warning that he had previously received. The officer I guess, detained and arrested the individual. The recommendation from the state, and again, this is as a result of him having an open case, two open cases. One is actually in one is actually in May of this year. The other one is in June of this year. But the recommendation from the state is a $500 surety bond, no alcohol, drugs, or weapons, and a stay away from that Comfort Inn Suites located at 795 Pollard Boulevard, Southwest Atlanta, Georgia, here in Fulton County, Georgia. There's nothing further to add from the state at this time, however.
And you recommended a 500 surety or 5,000?
Oh, 500. And
Okay.
again, that's on the basis of his criminal history.
All right. PD Wright?
Yes, Your Honor. It's just like the state said, he was caught eating breakfast at the Comfort Inn twice because he's homeless. I let him know that we can speak. I'll send a social worker to speak to him to try and get him placement, hopefully through PAD. He does require medication that he doesn't currently have access to. That's part of the problem. I'd ask that Your Honor consider the bond become a signature bond once we find him placement in the community, so that we're able to give him services and he's not just sitting in jail. He won't be able to get out on a $500 surety bond.
So let me make sure I understand what you're asking. You're asking for me to order the $500 surety bond that then turns into a signature bond? Is that what you said?
If we're able to find him a placement, yes. Unless Your Honor is inclined to turn the $500 surety bond into a signature bond. I'm not sure if he's eligible because of his
ready to say with the new bond restrictions, it says the second one.
Right.
So, and I believe he already had one. He has an open case now.
Yes, Your Honor.
Right down for trespass. I'm going to give him a $500 surety bond. To stay away from the hotel at 795 Pollard Boulevard. No drugs, alcohol, weapons, or guns while on bond. And stay away. Guess there doesn't need to be any contact either. No drugs, alcohol, weapons, or guns while on bond. 500 surety.
Yes, Your Honor.
Okay. What do we have next?
This is an add-on position number 3, Smith.
Yes, Your Honor, this will be Charity Smith, case number 24 CR 008325E, charged with theft by deception.
7, 2019 shoplifting dismissed. 2019 possession of marijuana dismissed. 2013 forgery in the third. Theft by deception, possession of false ID, first offender. Jail with the recommendation.
Okay.
Your Honor, this is an incident that actually took place on September the 9th of 2023. It was investigated by loss prevention at Home Depot. The report was made at the Home Depot at Holcomb Bridge. That's 1580 Holcomb Bridge Road in Roswell. The defendant was seen by loss prevention coming into the location with items in a bag, going to a shelf where she took what are described as are cat jacks, value, 6 of them, value total of about $300. She then walked over to customer service and tried to return those items. That request was denied because there was no receipt. Loss prevention then observed her walk down the aisle, call someone on the phone, and then present what looked like a digital receipt on a phone to customer service, who then promptly refunded her $307.15. Investigation revealed that on the same day at a different Home Depot, these items were purchased and returned by someone else or the defendant, maybe her sister, and that the return was a false return. It was a deceptive return. She'd already received the items, got reimbursed back for them, and was perpetuating a fraud. The only criminal history this individual has is based on fraud and forgery, and it looks like nothing has happened since a 2019 shoplifting null pros. We're asking for a $1,000 SOB through pretrial to stay away from Home Depot at Roswell Road, 1580 Holcomb Bridge Road, Your Honor. Thank you.
Who's representing? Is it Sheridan Smith?
This is Dota's case.
Oh, let's see, where did he go?
Oh,
there we are.
My apologies, Your Honor. I'm sorry, I lost Wi-Fi. Am I back?
Yes, you're back.
Okay, thank you. Yes, Your Honor, Miss Smith is 37 years old. My apologies if I missed anything. I tried to reconnect my audio. I have good contact information. She's a lifelong resident of Georgia. She currently resides in Columbus, Georgia, along with her sister, and she is a parent to 3 children, who she provides for as the primary provider: a 9-year-old, a 3-year-old, and a 6-month-old. She is a full-time mother and is assisted with her sister Chastity Smith. Your Honor, she refutes the allegations in this. My understanding is that there was some issue involving her niece using an ID at the time. Your Honor, we of course are going to ask for security footage and body cam to verify these claims, but she says that she was in Columbus, Georgia, and she was not involved in this incident at all. So we would just ask for signature bond through the jail while we try to piece this together and get something to provide the court and the state with.
Right there. Between these two.
Okay. I will order a $3,000 signature bond through the jail. No drugs, alcohol, weapons, or guns while on bond. Stay away from that Home Depot on, is it Roswell Road?
It's Holcomb Bridge Road, Your Honor.
Oh, Holcomb Bridge in Roswell.
Thank you.
Sometimes I order them to stay away from all Home Depots in Fulton County while they're on bond. Would you like me to do that, State?
We would not object, Your Honor.
I was gonna say, stay away from all Home Depots. Don't go to any of them. And
that's just in Fulton County, Your Honor, because she does reside in Columbus, Georgia.
yeah,
to clarify.
Fulton County.
Okay, yeah, I don't.
Mm-hmm. In Fulton County. And make sure we have good contact for her. No drugs, alcohol, weapons, or guns while on bond. And that should be it.
Thank you, Judge.
Mm-hmm.
And Your Honor, I put in the chat, but while we still have ACDC, I wanted to see if we could briefly readdress positions 14 and 15, Ms. Jones.
Okay.
Your Honor, I missed this earlier, but I would ask the court to consider a motion to dismiss based on the accusations not being timely. It looks like both of the accusations are after the 2-year statute of limitation period. I don't see anything in either accusation about tolling or anything like that. So I don't think either of them are timely.
Your Honor, the state became aware of these offenses quite some time after Miss Jones actually committed the offenses. I believe you may recall when I recited the facts, I relayed that one of the offenses was discovered when the apartment complex began proceeding with an eviction against one of the residents who Ms. Jones repeatedly collected rent checks from over the course of months, several months, before her scheme was eventually discovered. These circumstances were not made known to police until April of 2023. So we believe there was, that we meet the statute of limitations based on that information.
And Your Honor, I would just respond with Jackson v. State, which states that statute of limitations in criminal cases runs from the time of the criminal act to the time of the charging document. That is 306 Georgia 266-269. That's a 2019 case. And again, neither accusation has any tolling information or any extenuating circumstances.
And the scheme was continuing beyond the date of the first offense. And but for the eviction proceeding being brought against one of the residents, it would not have been known to the resident or to law enforcement, who opened an investigation the following year in 2023.
And Your Honor, I don't have any information on that. Nothing's on any scheme in the accusation or any of the warrants.
Okay, we do not.
I don't see anything, Your Honor.
Do you state?
No, Your Honor.
So I'm concerned on the statute of limitation. State, can you address that a little more? Are you out of time?
No,
My
Your Honor,
apologies.
we believe
Yeah.
the accusation is timely because when the scheme was discovered by both the victim and the state, it was reported, and it was not reported until April of 2023. So we are well within the statute of limitations.
Wasn't reported until April, and not the date of the occurrence, but when it became known for you all to
Correct.
talk. Okay.
Correct.
And this is for what's the defendant's last name again?
Jones.
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 Positions 14 and 15, Your Honor.
Right. Okay. I will not dismiss it at this time, based on the statute of limitations, because they did not become aware of the offenses until 2023. And so on the first one, with Ms. Jones, I think it was a signature bond through pretrial.
It was, Your Honor.
Okay. Yeah, so I don't
And
think that,
is there a case that the state or the court is citing to, so I can try to address, and because I'm not seeing what's going against Jackson v. State, but I want to make sure I'm addressing the court's concerns in the future.
okay.
Well,
You all have the citation at all?
I have a citation, but they cannot accuse a crime until the crime becomes until the state becomes aware of it.
I'm just saying, does anything go against what Jackson v. State said in 2019, which was that
We'll talk about that later, Mr. Dotis.
I'm just asking if there was a case.
there.
That's all I asked. I'm not, and I guess the answer is no then. Thank you.
All right, thank you. File your motions, Mr. Dotis. All right, next, who do we have?
Position number 2, Mr. Blackwell.
Okay. This is 24 CR 008308J, Sean Blackwell, charged with 2 counts of simple battery, family violence.
25, on probation, DeKalb County. Ag assault, possession of a firearm by convicted felon or felony first offender, possession of a Schedule 4 controlled substance, 2019 battery conviction, 2015 battery DV, hindering 911 call conviction, and an 09 conviction related to a CWAC charge.
Got a brief facts of the case is that on what appears to be 9/2/2024, the officer was dispatched to 785 North Elizabeth Place, Northwest, for a a domestic call for service. That location is in Fulton County. The caller, the victim, advised that the father of her child, who is the defendant here today, put his hands on her and their son. She stated that the defendant was mad because he could not find the remote for their living room television, and he began yelling and cursing at them. The victim advised that after he began yelling at the son, he then walked outside of the home, and when he came back and returned, he then punched the son in the chest for not giving him the remote. The victim stated that after he punched their son, she attempted to get in between the two of them. However, the defendant grabbed her left arm, twisted it, and then threw her to the ground and began banging her head onto the floor. Your Honor, we've already heard about the 25 cycles that he's collected. I would like to note that his 2020 conviction for battery was originally listed as an arrest for ag assault, to which he ultimately pled down to battery. The recommendation from the state in this matter is a $3,000 surety bond, no alcohol, drugs, or weapons, a stay away from that incident location, no further contact with either victim in this matter. The victim is listed as Sharie, Sheria, Robertson, traditional spelling, Robertson. The initials for the juvenile victim, that is the subject of the second simple battery family violence, is MB. And we'd like for him to complete a family violence intervention program as a condition of his bond. If we could sound for Miss Robertson in accordance with Marcy's law, that'd be greatly appreciated, but there's nothing further to add from the state at this time.
Okay. Ms. Robertson, was it Sharia Robertson?
That is correct.
Ms. Robertson, are you on the Zoom? I don't think I see anybody that fits that name. All right, go ahead, PD Wright.
Yes, Your Honor. Mr. Blackwell is 55 years old. He works construction and he's also a tattoo artist. He does live with his 14-year-old son. He's lived in Georgia for over 30 years. I did let him know that the facts of the case would mean that Your Honor would probably order that he stay somewhere else. He let me know that he would be able to stay with his sister Charisse in Sewanee. We are asking for a signature bond on this case.
Now I'm going to order the $3,000 surety bond, $1,500 on each. And stay away from 785. Is it North Elizabeth Place Northwest or Elizabeth Place Northwest? He could have a one-time escort to go back to getting your personal belongings. It needs to reside somewhere else. And no further contact with the victim or the victim's son. No drugs, alcohol, weapons, or guns while on bond. That should be it.
Thank you, Your Honor.
Your Honor, repeat that bond amount again, please.
3,000 surety, 1,500 on each.
Thank you.
Number 23, Wiet.
This is 24 CR 008321E. Finesse or Finesse Winset, charged with 1 count of battery family violence.
First level.
Okay. State.
Thank you, Your Honor. This is an incident from the 25th of December. Police were called at about 12:26 a.m. to 2505 Godby Road in College Park. That is the comedy club there at that location. The 911 call was made by witnesses on the scene who reported a male had been assaulted by a female at the location. On scene, the victim, named Thomas Johnson, reported that the mother of his child had assaulted him. He had scratches that were visible on the bridge of his nose and the area underneath his eye. The defendant was located in her vehicle. She was instructed to step outside of the vehicle. And then witnesses were questioned. They talked about witnessing the defendant strike the victim. It's reported that she was giving people hugs, saying goodnight for the evening. There was some animosity. And when the victim asked for a hug, the defendant was angry and said, you know, what, you have money for people tonight. Why don't you have anything for me? And then struck the victim in the face. We did speak to Mr. Johnson today. He reports that he and the defendant are no longer in a relationship, but they do share a child. This is not the first time that there's been violence, but the first time police have been called. He's requesting no contact. We'd be asking for a $2,000 SOB, Your Honor. She's got no history, no drugs, alcohol, or weapons, no contact with Mr. Thomas Johnson, and a stay away from his residence. It's a Cummings, Georgia address, 2290 Rebel Road in Cummings. And if you could sound for Mr. Johnson. Thank you.
All right, Mr. Thomas Johnson,
Yes, Your Honor, I'm here.
do you wish to address the court today? Yes or no?
Yes,
All right, raise your right hand for me so I can swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
yes, Your Honor.
All right, put your hand down. Are you in fear of is it Winset or Whitset?
With it.
Whitset.
Yes, Your Honor, I do believe that she would try something again.
Okay, and do you want to have any further contact with them?
Not at the moment, Your Honor. I would like to give her time to calm down.
All right, and you all used to date and don't date anymore?
That part is incorrect. We have never dated. We just have a child together.
Just have a child together, okay.
Yes, ma'am.
How old is the child?
She's about to be 2 next month. So she's 1 year and 11 months.
Okay. I don't think I have anything else. Any cross-examination by the state or the PD?
Nothing from defense, Your Honor.
Okay. All right. You can go ahead, Mr. Doders.
Thank you, Judge. Ms. Whitsett is 29 years old. She's a lifelong resident of the state of Atlanta. She does have her mom here to support her. She does have her own address away from the alleged victim, Mr. Johnson. Your Honor, as has been stated, they do share a child, which they do co-parent together. We would just ask that they be allowed to do a third-party transfer, as it doesn't appear that Mr. Johnson wants contact, and Ms. Whitsett is fine with that, but we do want to make sure that there are no issues with transferring of the child, and we would agree with the state on the signature bond recommendation.
All right. That will be a $2,000 signature bond through pretrial level 1. And stay away from the 1225 Godby Road.
Am I able to say anything else?
Your Honor, that is the comedy club location.
Oh,
the stay away is
That's not what he's-
2290 Rebel Road in Cummings.
Oh, 2290 Rebel Road in
Cumming. Sorry.
So that's the address for the victim, Thomas Johnson. No drugs, alcohol, weapons, or guns while on bond.
Am I able to speak too?
I've asked you the pertinent questions. This is not the trial. This is the bond hearing.
Okay.
So there's something regarding the facts or those allegations I don't particularly want to hear it at this time, just as far as contact and making sure you're safe while on bond. So do you have anything else to add to that?
Well, I did want to ask how long that bond was for, just so I know.
And until the state goes with the next well, until there's been a conviction or sentencing or dismissal, whatever the disposition is. So as long as the case is open and active and there's been no disposition, no trial or conviction or either a dismissal or anything, then she would still be on bond.
Okay, thank you, Your Honor.
Mm-hmm. Anything else to add to that, State? Did I kind of say that right?
No, thank you, Your Honor.
Okay.
And Your Honor, did you include a third-party transfer of the child, or did I miss? I want to make sure I didn't miss that.
Oh, no, thank you. And if there's going to be a visitation allowed with the child, that be precipitated by a third party or someone, a neutral person that the two of them can agree on, I guess, or at least the mom anyway.
Your Honor, this case doesn't have anything to do with the transfer of custody of a child. I don't have any information about any court orders or anything as it relates to a child here.
I don't know. I just know that they share a child. I just want to make sure there's no.
Yeah, I believe we would need a transfer because
if they can't have
we switch back
contact,
and forth.
Yeah.
Can't have contact, but it's only if she allows it. I don't know. You said you all were not married, so I don't know if you've legitimate the child or do you have a parenting plan or an order for visitation?
I'm not. We don't have an order of visitation. I just pick up my daughter, when I take her for a few days, and
Mr. Johnson, have you filed anything with the Superior Court that asks that you be noted as the biological father of this child? Are you paying child support? Do you have an order of custody and visitation?
Yes, I am paying child support, and we have had a DNA test and all that.
Well, that wasn't her question. Her question was, do you have a visitation order?
I guess not.
Okay. So, at this point, the rights that you have as a father who has not married mom and that child is a product of no relationship, no marriage, her giving you access to the child through visitation and time is completely up to her and what she wants to do. So if you want to have rights to access to that child, you have to file for a legitimation.
All right, I'll do that. Thank you.
Okay. So I'm going to leave off the third party transfer.
Thank you.
All right. Next.
Petition number 5, Mr. Crabtree.
Okay.
Party.
5 is 24 CR 008323C Carlson. Is it Carty? Charged with 3 counts of battery family violence.
6 on probation, simple battery out of state court. Also for reckless conduct, failure to maintain lane driving without a valid driving with a suspended license. The last arrest was back in November for FTA.
That's my case, Your Honor. This is an incident from the 25th of December at about 12:30 a.m. Police in Roswell were called to 120 Big Creek Court. There, they spoke with the victim in this case. His name is Cameron, same last name as Carty, C-A-R-T-Y. It was reported that the defendant, who is the brother of the victim, they lived together at that location, came home intoxicated, repeatedly punched the victim in the face and head and strangled him. He had bruising around his left eye, around his ear on the left side, and the victim reported that he had been put in a chokehold. Police noted that he had bruising around his neck when they spoke to him on the scene. The defendant was asleep in his bedroom. The victim was asked to go get him. He went and got his brother. The defendant was not cooperative. He kept saying he wanted to just go back to sleep. And then the victim at that point stopped being really cooperative and didn't want to answer any questions about the reality that he had probably just been strangled because there was bruising and injury specifically noted to his neck. We did a strangulation assessment, and this case has not been escalated to a felony level charge with the DA's office at this point. We did speak to the victim. He reports that they're brothers and they live together. He confirmed what happened, said that he didn't feel like he was going to pass out, that there's been violence in the past, but he can't recall if he's ever called the police before. He's not in fear. And the only reason that this incident stopped is because the parents intervened. So based on the facts and the severity of this assault, we're asking for a $6,000 surety. Your Honor, the almost entire criminal history of this gentleman is for drugs or DUI. He is currently on probation for simple battery family violence. And the victim is another family member, last name Carty. That's 23 CR 005679C. So we'd be requesting a $6,000 surety, stay away from that location. Again, that's 120 Big Creek Court in Roswell. No contact with Cameron Carty, and that is spelled CAMRIN, and no drugs, alcohol, or weapons. Thank you.
All right.
Yes, Your Honor.
PD Wright.
Yes, ma'am. Mr. Carty is 32 years old. He works full-time for Chili's. He lives with his two other brothers, and the three of them do take care of their parents. I would ask Your Honor to not order a no further contact. My understanding is that the brother does want contact and is not in fear for his life. If Your Honor would like to do a violence intervention program instead, I think that could be appropriate. And we would ask for a signature bond if possible.
Now I'm going to order the $6,000 surety bond, $2,000 on each of the batteries. So that'd be a total of $6,000. It's part of the contact. I will just again, and this says they were brothers, correct, but they don't live together.
They do live together, Your Honor, and the open
they
case
do.
or the probation case that this defendant has is for violence against his other brother, who also lives at the location.
Oh, okay. So I'm gonna have to order a stay away from that location. No further contact with the victim brother, and I did not catch his first name.
Your Honor, it's Cameron, and it's spelled CAMRIN.
Oh, Cameron. Okay. All right, and no drugs, alcohol, weapons, or guns while on bond. And I think that's it. Anything else?
No, Your Honor.
Okay.
Next, we will go to position number 8, Mr. Davis.
Okay. This is 24 CR 008313E. Mr. Davis is charged with 1 count of simple battery, family violence.
First level 1.
Okay. Date.
And a brief facts of the case. One moment. Which Davis is this? I'm sorry.
H. Davis.
Thank you very much. Brief facts of the case is that on December 26, 2000, I'm sorry. So yes, it said December 26, 2024, the victim went into the Zone 1 precinct to file a complaint against her fiance, the defendant. The victim stated that the defendant grabbed her duffel bag, attempting to kick her out of the apartment. She stated that she grabbed the duffel bag when she And she started back and forth, and that started a back and forth between them over the control for the duffel bag. The defendant used his shoulder to push her to get control of the duffel bag. She stated that she left the apartment and was in the hallway attempting to leave when the defendant came up behind her, grabbed her, and wrapped his arms around her as she was trying to stop him, as an effort to stop her from leaving. The victim stated that she felt scared and fear at the moment and told the defendant to let her go. Fortunately enough, our office was able to get in contact with this victim. That victim is Sandy, Sandy Foster, Foster. She advised that she and the defendant are in a relationship. They live together at the incident location. They share no children. She confirmed the events in the warrant. She stated that nothing like this has ever happened before. She stated that she is not in fear of the defendant. She states that she wants continued contact. She also wants the defendant to return to the residence, and she will be on Zoom. So if we can sound for it at the conclusion of the state's request. But the state's request in this matter is, given the limited criminal history and the nature of the charges, is a signature bond through the pretrial services, no alcohol, drugs, or weapons, and no further violent contact with the victim. And if we could sound for it in accordance with Marcy's law, that'd be greatly appreciated. Nothing further to add from the state at this time.
All right, I see
am
a
also
Ms.
here.
Foster. Okay, do you wish to address the court today, Ms. Foster? Yes or no?
Yes, Your Honor.
You do need to turn on your camera.
1
And
second.
it sounds like you're driving, so you got to pull over. I hear you blinking.
Yes, ma'am. Let me just pull over really quick.
Definitely can't talk to you while you're driving.
So sorry, Your Honor.
Your internet, your contact is bad.
Okay, can you hear me?
I was just making sure you pulled over.
Yes, ma'am.
Okay. If you want to address the court today, I need to swear you in first. Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your
Okay.
Honor.
Do you want to have any contact with Mr. Davis? And I'm not for sure how to pronounce his first name.
Yes,
so I
ma'am.
wasn't going to mess that up. How do you pronounce it?
Harmaku?
Okay. Do you want to have any further contact with him?
Yes,
Are you
Your
in
Honor.
fear of him?
No, Your Honor.
Okay. All right. Any cross-examination questions?
No, Your Honor.
Not from the state, Your Honor. Thank you.
All right. Thank you. You can mute yourself and wait till I give my ruling in a second. All right. PD Wright?
Your Honor, we are in agreement with the state. We think a signature bond and a no further violent contact would suffice.
Okay. I'm going to order $3,000 signature bond through pretrial. And with that signature bond through pretrial, it'll be a level 1. And I'm going to order 2-day anger awareness course through pretrial. I'm going to order no further violent contact with the victim, Sandy Foster. And no drugs, alcohol, weapons, or guns while on bond.
Thank you, Your Honor.
What's the amount and level?
3,000 SOB pretrial level 1.
Next, we can go to number 9. Something funny.
I'm sorry.
You go to number position 9. Mr. David.
Okay. All right. Thank you, Ms. Foster. You're free to go. Position 9 is 24 CR 008314F. Jeremy Davis, charged with 1 count of battery, family violence, and a 2nd count of interference with custody. Pretrial.
11 on probation for theft by taking out of Superior Court. Got an open case out of Coweta County. Fleeing an officer, possession of a Schedule 1 or 2 narcotic, kidnapping, possession of marijuana, suspended license. 2017 theft by taking conviction, 2010 FTA. That's it.
Okay.
A brief facts of the case is that on June 26th, 2024, the Special Victim Unit got involved in a dispute that occurred at 3000 Stone Hogan Connector Road at apartment number 2. basically the victim had to, and also the victim in this case had to relocate to 499 Northside Circle. The victim in this case, Ms. Clark, advised that she was at her home with the father of her child, who got mad at her and accused her of cheating on him, even though they were not even in a relationship. She stated that she was working from home, and while she was doing her online training, he became physical with her. He began to hit her with a closed fist. He threw her down a flight of steps. He knocked over her work equipment. The victim also mentioned that the defendant took their child, who I will refer to as SD, who is a juvenile, from the location in his vehicle. The victim also stated that the defendant had other children that were there in the apartment when this all happened. Their names are SD as well, both of them. According to, it's two other children, by the way. According to the victim, the defendant had not legitimized their son. Grady EMS advised that they noticed bruises to the victim's chest, elbows, arms, and a few abrasions on the victim as she complained about neck pain. The victim left the location because her friend, Diamond Clyburn, heard the dispute happen over FaceTime, and the friend had to call her an Uber to get her out of the apartment. The victim was transported to Northside Hospital by Grady EMS. Your Honor, unfortunately, our office has not been able to get in contact with the victim, but if we could sign for her at the conclusion of the state's request, her name is Ariana, Ariana Clark, Clark. Your Honor, the pretrial has already told us about the presence of 11 cycles. This person is a multi-state offender. They were on probation at the time of this offense, as well as I'd like to highlight that kidnapping charge to which they were recently arrested for. The request by the state is a $6,000 surety bond, no alcohol, drugs, or weapons, a stay away from the incident location, no contact with either victim in this case, and the completion of a family violence intervention program. If we could sound for her in accordance with Marcy's law, that'd be greatly appreciated. Nothing further to add from the state at this time.
All right, Ariana Clark. Ariana Clark. Nope. All right, go ahead, PD Wright. Oh, you're muted.
I'm sorry about that, Your Honor.
Okay.
Mr. Davis is 34 years old. He works both at Honey Baked Ham and he's also a mail sorter through the travel app. He has 3 children. 2 of them, the oldest two, 13 and 10, live with him. The 3-year-old lives with Miss Clark. He has lived in Georgia for about 11 years. Miss Clark currently lives in Pittsburgh. Mr. Davis has been working a program called Fatherhood Incorporated. They did let him know that since Miss Clark lives in a different state, he would have to reach out to that court's programs to see how to legitimize their children. My understanding is that he and Miss Clark do have a good working co-parent relationship. He speaks to his son pretty frequently. All parties involved want contact and they do want a relationship. I do have a phone number for Miss Clark if the state doesn't have one. As far as his criminal history, I understand that he's likely not eligible for a signature bond. I would ask Your Honor to consider a much lower bond amount. He is willing to work any program. He just wants to be able to keep his jobs. The Honey Baked Ham job is a holiday job, but the mail sorter through travel app is a bit more long-term. He also let me know that Miss Clark is working a parenting program as well. It's difficult because she's not here. I hate speaking about her when she's not here, but it looks like they're both dedicated to try to be better people and be better parents. The risk of any kind of violence or reoffending or anything like that towards her is kind of non-existent right now, considering she's in a different state. So again, we would ask Your Honor to consider a much lower bond for him.
Well, based on the allegations, not gonna do a signature bond. I'll do a surety bond. And I will do 5,000 surety bond, with the first charge being 3,000 and the second charge being 2,000. With that surety bond, is that a stay away from 3,000 Stonehogan connector? Or is that not her?
That is, yeah.
address? Okay. Stay away from that location. No further contact with the victim, Ms. Clark. And no drugs, alcohol, weapons, or guns while on bond.
Thank you, Your
That
Honor.
should be it.
Thank you, Your Honor. And I just want to let the court know that the state is filing an amended accusation. There is a 2-day discrepancy in the offense date.
Oh, yeah, because I thought I heard you say the 26th maybe, and it's the
Yeah,
28th on the calendar.
it's
Okay.
actually the 26th.
Okay. All right. Next.
Position 11, Mr. Harris.
This is 24 CR 008301G, Tyrone Harris, charged with 1 count of criminal trespass. Pretrial.
Third arrest, 2024 theft of services. That was last month out of Pittsburgh. He was arrested this month in Baltimore. Trespass, theft, disorderly conduct that appears to be open, and a resident of Tampa, Florida.
Okay, state.
What's the position number, Your Honor?
11.
Mr. Harris?
Yes.
One second. Ms. Sears, is this your case? I just got a big list, so hold on.
Sorry, what was
It's
name?
Mr. Harris,
This is
number
11.
11, Tirone.
Okay.
Thank you.
Thank you for bringing that to my attention. Yes. The state's recommendation in this case is a $2,500 signature bond. Do not return to the Greyhound bus station at 232 Forsyth Street. The alleged facts are the defendant refused to leave the Greyhound bus station when asked several times by staff at the location. The police were called to the scene and the defendant was still there, and they requested several times that he leave the premises and not returned. The defendant refused, his reasoning being that he is a sovereign citizen and did not need to leave. I believe it's important to bring to the court's attention that he has 2 open matters in Baltimore, Maryland, for trespassing on private property, and on December 4th, and another one on December 11th of 2024. I believe he's on bond for both of those right now.
All right. PD, right?
Yes, Your Honor. I believe the state asked for a signature bond on this case, and we would agree with it.
Well, I'm going to order a $2,500 and this one he didn't have another criminal trespass. This is his first, right?
I'm sorry, I meant to say surety bond, $2,500 surety bond. I may have said signature. That was my error. And my reasoning being that defendant does not have sufficient contacts to the state. he has a Tampa address on his driver's license and 2 open cases out of state currently.
Oh, that's right. He did say that. 2 open, and I wrote down resident of Tampa, Florida. Okay.
Well, then my tune will change, Your Honor.
Oh, no, right? Yes.
Um,
Sorry about that.
No,
Yeah.
I get it. Your Honor, Mr. Harris is 30 years old. He does live in Tampa, which is just one state over. He is self-employed. He did graduate from high school. And he finished 2 years in college at the Hillsborough Community College down in Tampa. He was in Atlanta for business. And as far as being from a different state being an issue, I don't think I heard in his criminal history that he has any failure to appears. So I would ask this court to not count the fact that he lives in a different state against him, as we don't have any evidence that he wouldn't show up to court when asked to do so. And I would ask that $2,500 be a signature bond, not a surety bond.
I'm going to reduce it to a $2,000 surety bond. And with that $2,000 surety bond, it looks like to stay away from the Greyhound bus station.
Yes, Your Honor.
And no drugs, alcohol, weapons, or guns while on bond. And I think we didn't have a name, or did we, for a no further contact?
No, Your Honor.
None, Your Honor.
Okay. All right. No drugs, alcohol, weapons, or guns while on bond. And that should do it.
We can go to position number 21, Mr. Shellman. Mr. Shellman. This is McLeod's case.
It's whose case? Ms. McLeod?
I believe that's what they just said, Your Honor. Yeah.
Yeah. This is your case, Ms. McLeod. Thomas Shellman, 21.
Yes.
Okay. 24 CR 008316Y. He's charged with 1 count of battery. Pre-trial?
29. 2022 probation. 2022 DUI, 2020 FTA. 2019 probation, 2018 FTA. I think the last violent arrest I saw was in the early 2000s.
Okay.
Your Honor, that's true. The majority of the criminal history for this gentleman is DUI convictions and drug convictions. This incident happened on the 25th at 189 Oak Street, apartment 34. Police were called at about 5 p.m. And this is in Roswell. They met with the victim. Her name is Tirzah, Tirzah, last name Williams. She reported that she'd gone to the location to do some cooking for the holidays as requested by the people there. That's not her residence. The defendant, Mr. Thomas Shellman, was intoxicated. She went into a different room and closed the door where she was watching TV on her phone. The defendant came in and busted into the door and punched her in the face. She had visible injuries, swelling to her mouth and bleeding to her gums that was seen by police. She removed herself from the situation and called police for help. We'd asked for a $2,000 surety, Your Honor, no drugs, alcohol, or weapons, and no contact with the victim, in this case, Mrs. Williams. We'd also ask for a BHET or ADET if that's appropriate.
All right. Ms. McLeod?
Yes, Your Honor. My client is 64 years old. As pretrial has pointed out, he has no recent history. He works, he tells me, as a mechanic. And this person is not someone who he lives with or is in any kind of relationship with. He also denies that that is what happened. He does deny that he struck her. I would ask the court to consider giving him a signature bond so he can get out of jail, given that he has not been in any kind of trouble recently. And also, I believe it was said that most of his history was DUIs or drug related. Nothing further, Your Honor.
Okay. I'm gonna do the $2,000 surety bond. There's a number of encounters as well. And they stay away from the working home of Miss Williams.
No, Your Honor, she doesn't. She doesn't live there. She's not. They don't have a relationship of any sort. I believe she may know his girlfriend or something, but he doesn't have. She doesn't live there. She does not live at this location, and the warrant says that.
But it's not a problem for him to have no contact with her or to stay away from her residence or where she may work.
Right. He doesn't know where she lives, and that's fine. He can stay away from where she lives.
And that's what I think I said. No further contact with her at home or work, wherever that may be.
That's fine. We're good with
Okay.
that.
And no drugs, alcohol, weapons, or guns while on bond. So 2,000 surety.
Thank you, Your Honor.
All right, thank you.
That concludes my business before the court today. May I be excused?
Yes, you may. We need you, we'll call you. All right, thank you.
Next, we can go to position number 12, Mr. Hegler.
This is 24 CR 0083002C. John Hegler, charged at 1 count of theft by taking. Pretrial.
32. On probation for theft by taking is 20 SC 175242. 2020, they gave him 4 years, 6 months probation in August, so that should time out in February. Last arrest was on the 20th of this month for shoplifting. He went to ACDC for that. 2022 probation, 2019 theft by taking conviction, and before that was a 97 burglary he went to prison for. That's it.
Okay. Say.
Your Honor, Mr. Hegler is accused of stealing a bicycle that belonged to a Georgia State student, Mr. Karthik Krishnam. The defendant was observed on video surveillance after the victim reported his bike being stolen, and they conducted an investigation to determine who the person was that they saw on video taking the bike. Using facial recognition software, they were able to determine, based on the tattoo on his neck and a defect in the top of his head, that the defendant was the person on the video taking the bicycle from Georgia Tech, and issued warrants for his arrest. We would ask that the court issue a $1,500 surety bond because Mr. Hegler, since this incident occurred, has left the state and been in Mississippi and Louisiana and also had other offenses in the state of Georgia. And that while he is on bond for this offense, that he stay away from Georgia Tech, that there be no weapons, drugs, or alcohol, and of course, no contact with the victim, but they are strangers to one another.
Okay. All right. Oh, PD Wright, I'm sorry.
Yes, Your Honor. This offense allegedly happened back in August 16 of 2022, which is past the statute of limitations. So I would ask Your Honor to dismiss this case. My understanding is that the state's position is that because he left the state at some point, he is somehow a fugitive. I do not believe that that's what the state's law support. Additionally, my client was arrested just a few days ago, and he got a signature bond on that case. The state should have, at that point, addressed the bond for this case, and they did not. So he's been sitting in jail without a bond on this case and a signature bond on the other for a couple of days now. If the court is not inclined to dismiss the case on the statute of limitations issue, I would ask for a signature bond, especially considering the age of this case.
Your Honor, if I may.
Yes.
CGA 17-3-2, Section 1 says the period in which a prosecution must be commenced under Code Section 17-3-1 or other applicable statute does not include any period in which the accused is not usually and publicly a resident within the state. The reason why we know the defendant was not usually and publicly a resident within this state during the period, the time frame within which the statute of limitations could have run is because his criminal history reveals that he was arrested in Mississippi twice, once in 2023 and another time in 2024. So excluding those time periods within which the state could have accused the defendant of the offense of theft by taking, we are well within our statute of limitations to proceed with an accusation as has been drafted.
And Your Honor, being arrested in a different state does not mean that you are a resident of that state. In speaking to my client, he has always been a resident of the state of Georgia. He hasn't not been a resident of McDonough in that time. And I understand that he had other matters in Mississippi, but both things can be true. And I am sure that the attorneys that have to battle this out in court will do so, but I will ask Your Honor to give him a signature bond, especially in consideration that this should have been brought up days ago on his original arrest.
Was he
hold on
booked
real quick.
into our system?
Yeah,
days
so
ago?
he
Let's talk
got
about it.
arrested by the city of Atlanta, Anna, and he went to the city jail.
Right.
So once he may have gotten a signature bond there, then he came to our jail.
So once he's in our custody, Riverside starts. There's no Riverside violation here that needs to be addressed.
I'm not asking for a
Well, you're making an argument that's not based in the law then.
I'm not done speaking, Miss Allen.
You did stop.
No, Miss Allen, I am more
Okay.
than happy to let you make your argument once I'm done
No,
with
it's just responding to your erroneous statement. So go ahead. And
Why
we
don't
got
you go ahead and
clarification
continue
from Jay.
speaking, Miss Allen, since that's so important to you right now.
The date of this gentleman's booking was when he became into the custody of the Fulton County Jail as it relates to these charges, and this is his first appearance. So an argument that he's been in jail for days is not really valid here. He's been put in front of this judge as quickly as possible after whatever he was dealt with at the city jail was dealt with. Just like we can't go to Mississippi and get him out of jail there and provide him with documents showing the outstanding arrests for him here for crimes he committed here. There are limits to what we can do.
That is not true. The state of Georgia can absolutely put a hold on someone in a different state that has been arrested in a different state.
He's not under arrest.
I am not done speaking.
Honor, I'll be done.
Okay.
I provided some case law to your cohort. I believe Ms. Sears has done the same today. We'll be happy to go over it with you. And again, These are issues that'll be brought up in motions. This defendant is having his first appearance here in a timely manner on a case where the statute of limitations has been addressed because he was out of the state, and the specific law addresses that, and the statute's been provided. Thank
Your
you.
Honor, I am very uncomfortable with the state speaking over the defense. I think that we can be respectful and finish speaking our thoughts and making our arguments without cutting into each other. This is not personal. This is an argument that I have to make for my client. And I am not alleging any kind of personal issues with the state. I would, or with the state, I would ask that Your Honor remind Miss Allen that we both get time to speak, and it's quite rude and unhelpful to cut into each other's time the way that she has been doing with mine.
So, Ms. Wright, I apologize, but I believe that there was a question asked about the status of this defendant, and Mr. Toussaint Howard stepped in and was giving an answer, and you weren't talking, and nobody interrupted you.
Ms. Allen, you've
nobody was trying to
me
interrupt
many times. You've interrupted other people in this conversation many times.
Ma'am, I'm the supervisor here, and when somebody mistakes the law, it's part of our job, okay?
No, it's not actually part of your job to break into other people's conversations.
Hold on, everybody pause for a minute and hold on. We're not going to do this, okay? We're going to be professional. We're going to speak to each other with respect. So let's do that on both ends and give each other time. We won't cut them off and cut each other off and make your arguments. So I think the last place we left off was that there is no statute of limitation concern at the moment from the state's vantage point, and I have heard yours, Ms. Wright. I think it is better suited for a motion. I'm not going to dismiss it at this point based on the argument. I think the other one that we had with the statute of limitations, the accusation was not filed until the following year when the alleged crime, I guess they became aware of it. This one is a little different, I'm thinking, with Mr. Hegler, because 8/15/2022, then when was the accusation filed?
Today, I believe.
Today?
The same statute applies, and it's based on the fact that the defendant's unavailable. It's what Christina Sears, who's handling this case, already went into, and it's the same statute that was provided to the defense today by both of us, as well as case law.
Okay. Is that he was unavailable, could not be located. I think when they're not able to be located, that does.
It's about being publicly a resident within this state.
And Your Honor, my argument was that he was a resident of this state, that he was arrested in a different state. That doesn't make him not a resident of Georgia, and that the state of Georgia could have served him his warrants while he was arrested in a different state, just like Georgia puts holds on folks that have warrants in our state everywhere. It does not stop the state of Georgia from putting a hold on someone who is incarcerated somewhere else. They had the chance.
And I guess that's if they're aware. I mean, you would have to prove that in a motion that they were aware or knew.
Right. So the defendant is a transient, and he's not only been a resident of Georgia and Mississippi, where he was in custody, but also in St. Louis, Missouri, per his history. It's his criminal history that shows where he's been staying and laying his head, and it's not just Georgia. And I'm more than happy to discuss this with you further, but for today's purposes and the first appearance, we have met our burden. We are not disparaging your work. We are just wanting to move forward because nobody's going to be trying to infringe on your client's rights. The statute of limitations has some exceptions to it. And we're addressing two different ones today on this calendar in two different cases.
Two of the exceptions, yeah. Okay. Any other arguments on behalf of your client, PD Wright, as far as the bond?
No, Your Honor, I don't believe he has any failure to appears. When speaking to him, he let me know that he does have odds and ends jobs. He does live in McDonough. And he did have a signature bond on the last charge, so we'd ask for another signature bond.
But that last charge was when?
A few days ago, I'm not sure specifically.
Well, you know, my feeling is that they've already had one bite at a signature bond and then come back a few days later and get another charge. I don't reward them by giving them another signature bond because obviously they didn't
Oh, Your Honor,
appreciate.
this is a 2-year-old case, so this happened way before his case
Oh,
from a couple
you were
days.
just telling me the date of his last arrest.
Yes.
Okay. I thought you were saying something different. My apologies to that. My other concern is the 32 cycles. I understand that, and I heard prior theft by taking as well. Did I not?
I'm not sure, Your Honor.
I believe I did. Did you catch that? ASG
There
Allen?
were.
There were.
There
Yeah,
were,
I'm sorry. Sears.
burglary priors alleged against this defendant.
Right. I'm going to go ahead and order the 1,500 surety. Stay away from all of Georgia Tech's property, which is really vast. I mean, it's, you know, over a lot of downtown Atlanta. So he needs to stay off of any property labeled as property of Georgia Tech. No drugs, alcohol, weapons, or guns while on bond. And any other conditions requested by the state or that I looked over?
Nothing further, Your Honor.
Okay, thank you.
Have a seat in the borough. You got a seat in the borough. Next, we can go to position number 13, Mr. Jones.
You said 13? Okay. 24 CR 008303G, Lebron Jones, 1 count of simple battery family violence, pretrial.
I ain't do his total. He got appear to have an open case out of Tennessee, violation of community supervision. It says for life. And 3 counts dealing with the CWAC charge. I also got open case for theft of property. Another charge, 3 counts dealing with CWAC. Open vandalism, malicious mischief, ag assault, battery of a sexual nature, interference with emergency calls, false imprisonment. Got open DUI, driver to exercise due care. Another open ag assault, 2014 robbery conviction. 01 battery ag assault conviction. He got a lot of probations and a resident of Chattanooga. That's what I got.
That sound right good.
Mac, Dion Mac, please mute yourself.
Huh?
Mute yourself.
Your Honor, Ms. Mack, the victim in this particular case.
Oh, that's in this case, right?
Yes.
Okay. But I just don't, any others that are on this calendar, see a few other names. Please keep yourself muted until the court has allowed you to speak. And so be careful pressing buttons and things that you unmute yourself and disturb the court or speak when not given permission to speak. Thank you. All right, go ahead, ASG Sears.
Yes, Your Honor. These events occurred on Christmas Day at 1099 La Rosa Terrace Southwest, where the defendant, Mr. Jones, and the victim, Ms. Dion Mack, had recently moved in and were in a room that they shared. The victim reported that she was lying down in the bed when the defendant placed both hands around her neck and applied substantial pressure. The victim reported to the police when they responded that this is not the first time that the defendant has attempted strangulation, and on one previous occasion, the victim lost consciousness. She had a visible injury to her eye, which was not caused in this incident per the victim, but in a separate incident that occurred recently in Tennessee, which he inflicted by striking her. we would ask that the court impose a $5,000 surety bond, and he have no further violent contact with the victim who is on the line, and no weapons, drugs, or alcohol while on bond, that he take the 2-day anger assessment class while he is on bond as well, and any other conditions that the court sees deems appropriate given the circumstances.
All right. PD Wright?
Oh, Your Honor, I think the state said that the complaining witness was on the line.
Oh, I'm sorry. Yes, she was. Miss Mack, where did she drop off? Do I see? It was what, a Dion Mack, right?
I thought I saw her earlier.
I did too. I
She
think
was
she's dropped off.
falling off.
I'm sorry, Mr. Jordan.
She's logging back on.
Oh, she's logging back. Okay. Well, hold on a second. All right, Miss Mack, do you wish to address the court today? Yes or no? Can't hear you. You're on mute. See your mute button?
Yes, I want to address the court.
Okay, do you wish to address the court?
Yes, ma'am.
Okay, raise your right hand so I can swear you in first, and can you stop walking? Or get into a stationary position? All right. Okay. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. Are you in fear of is it Lebron Jones?
No.
Okay, do you want to have any further contact with Mr. Jones?
Yes, I do.
You do? Okay. You all reside together, correct?
Yes, ma'am.
Okay. All right, any cross-examination by the state?
None at this time, Your Honor. Thank you.
Okay, PD Wright.
Yes, Your Honor. No cross-examination of Miss Mack.
Okay. Miss Mack, you can mute yourself again and listen to the ruling.
Okay.
All right, thank you. All right, go ahead.
Yes, Your Honor. Mr. Jones has lived in Atlanta for about 25 years. He's 63 years old. He's retired, but he does home remodeling jobs on the side. He graduated with an 11th grade education. He's been engaged to the complaining witness for about 6 months. My understanding is that they both live at 1094 La Rosa Terrace. And I would ask, since the complaining witness is non-fear and wants him back home, I would ask that Your Honor grant a signature bond so that he may be able to do that. And I'm sure he will, oh no, that's it. That's it, Your Honor.
Okay. All right, I'm a little concerned about the allegations and as well as the history of the defendant. So I'm going to order a $1,500 surety bond. And with that surety bond, I'm going to order a stay away. Well, I'm sorry, let me back up. I'm going to order no further violent contact based on the victim's request, but I'm very concerned about it. I'm very reluctant to do it because we're talking about choking and things of that nature. Those are very serious allegations. And he's definitely got some violence in his history. I think since this just happened and we're less than 24 hours, I'm going to let me back up and do the stay away from 1099 La Rosa Terrace right now to make sure there's going to be the ample cooling down. Let me also order no further contact right now, even though the victim stated that she wanted to have contact, but I'm going to order no contact right now and that they stay away from each other. If PD Wright, if you want to file a a motion to amend the order. We'll address that at that time. But right now, I think there needs to be some cooling down.
Yes, Your
I'm
Honor.
going to, huh?
My apologies. I just wanted to let you know that that was something that I spoke with Mr. Jones about, and he does have a place to go.
Okay, good. That is good. Let's do that and make sure that we're beyond this. Also no drugs, alcohol, weapons, or guns while on bond. And I think that'll be it. Stay away and no further contact right now.
Yes, Your Honor. Thank you.
All right, thank you.
Next, we will go to position number 17, Mr. Parks.
Okay.
What was the bond for 13?
1,500 surety. This 24 CR 008315A Sharif Parks, charged at 1 count of simple battery family violence. Retrial.
18 total. 2022 DUI. 2018 FTA. 2016 battery DV false imprisonment conviction. 2015 terrorist threats obstruction conviction. 2015 battery NOLA.
Okay. State.
Your Honor, this is my case. These events occurred November 10th, 2024 at 1124 Wiley Street, Southeast Atlanta, Georgia. The victim is Deja Robinson. Ms. Robinson is present and on the Zoom, and I believe would like to address the court, if I'm not mistaken, yes. These events occurred during the custody exchange of their 5-year-old son, where the defendant is alleged to have pushed the victim. When the police arrived, a bystander reported that a man and a woman were fighting in the parking lot, and that the man involved was fleeing the scene in a black Honda Accord. The police spoke to Deja Robinson, who advised, consistent with what had been reported on the 911 call and by the bystander who spoke to police. And it was a verbal argument that ballooned into a physical altercation, at which time the defendant threatened that the victim would never see her child again. The five-year-old son was present for these acts. Because the defendant was not at the location, warrants were sought for his arrest. The location is the defendant's address. We are asking for a $5,000 surety bond. That he had no violent contact with the victim. That custody exchange take place in accordance with the court order, except that they occur at a police station going forward. That there be no weapons, drugs, or alcohol in the defendant's possession or use while he is on bond in this particular case. Hold on 1 second. The victim is advising that since this incident occurred, she has been prohibited from seeing her child, and she wants to know what the location is of her child.
So the child is not with Miss Deja Robinson?
No, Your
Is that
Honor.
what you're saying? Okay. All right, go ahead. Oh, Mr. Dotis, this is your case.
Yes, Mr. Parks, I do see your hand. We can talk after court, but I'm gonna ask you to let me speak today.
Did you want to hear from the victim, Your Honor?
Oh, I'm sorry. Yeah, my apologies.
I'm sorry. We both forgot. Thank you.
Yeah, my apologies, Miss Sears.
Yes.
No worries.
Deja Robinson, Miss Robinson,
Yes, I'm here.
do you wish to address the court today?
Yes.
You need to turn on your camera.
Okay, here.
All right. Raise your right hand for me so I can swear you in first. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Ooh, say that again?
Yes.
Okay. Your contact was a little fuzzy. You can put your hand down. Are you not driving? Or are you driving?
No, ma'am. I'm just sitting in the car. No, I'm
Okay.
sitting in the car.
Okay. All right. I got two questions for you. Are you in fear of Mr. Sharif Parks?
I'm gonna say I don't. It's always something with Sharif. It's a time where I don't be in fear, and it's a time where I do because of how he is. 1 minute everything could be good and on like one accord, then the next minute this man is just spazzing out randomly, and I don't be knowing where it come from. Like I asked him, "Can I get my son for Christmas?" The agreement was yes. I asked Sharif, I was like, "Hey, this is like 2 weeks ago." I was like, "Hey, can I come get Sharif?" He was like, "You can get him whenever you want to. That's your son."
Well,
So
let me
then shortly
ask
after that,
you.
he was like, "You're
I'm not gonna
selfish."
hold on. I'm not gonna go over your custody and visitation because that's not what we're here
Well,
for.
basically, sometimes it's fear and sometimes it's not.
Okay. And let's stop there. Who has custody, legal custody of your son?
He has temporary custody.
Temporary custody? And do you have visitation rights in that temporary custody order?
The visitation rights that he does not follow.
Okay. All right. But you do have an order, is what I'm asking.
Yes, and that
And
court
that's through
order
the
has not been
Superior Court,
followed.
and is that through Superior Court or Juvenile Court?
This is juvenile court in Cobb County, Georgia.
Juvenile Court in Cobb County? Okay. There is a delay on your camera. I don't know if you have a good connection or not. And now it looks like, well, you were
Yeah.
just frozen. Now you're not frozen. The connection's not good. Or wherever you are is not a good area. So we'll see. Okay. So do you want to have further contact with Mr. Parks?
If it's going to continue to be all of this, then no.
Okay.
I'd rather
All right.
just do it the legal way.
Okay. All right. Any cross-examination of this witness?
None, Your Honor.
All right.
Nothing
ahead.
from defense, Your Honor.
Okay. And then go ahead, Mr. Dotis.
Thank you, Your Honor. Mr. Parks is 38 years old. As we heard from the state, he does reside at that incident location, but that's not where Ms. Robinson resides. So we would ask he be allowed to return there. Your Honor, I do have good contact information for him, and he has been a resident of Atlanta for at least the past 6 years. He has family in the area, including a sister, Rashida. He is the father of two children, the 5-year-old he shares with Miss Robinson, as well as a 20-year-old that he also provides support for. He attended college at Georgia Piedmont, where he studied, he got certifications in heavy equipment managing and marketing, and he's currently a maintenance manager for Pavilion Leasing, which he's hopeful that he can return to that job. Your Honor, this incident, it appears that it did occur while the child was being dropped off. And based on what Miss Robinson stated, my apologies. I'm sorry. Someone just sent me a direct message. I just want to make sure it wasn't about this case. I think based on what Miss Robinson said, I think a third-party transfer would be appropriate, and for the parties to, if there is no further violent I think a third party transfer after speaking with Mr. Parks would be appropriate and to abide by whatever the custody agreement is. I haven't had a chance to look into that, and I've advised Mr. Parks of next steps outside of the criminal system with that. I do understand that he has temporary custody of the child for now. But again, I haven't seen whatever is written in Cobb County. Your Honor, at this time, we would just ask for a signature bond, any conditions the court deems appropriate. And I think third-party transfer until we have a cooling off period.
Right. I don't want to do anything that would be contradictory to that temporary custody and visitation order. So all I will say about that is the parties continue to follow it, because I don't want to get into that or make an order about visitation that is contradictory to what that order states. And if Miss Robinson needs to go back to court to address that, then she can do that. But I'm just going to say parties need to follow it. It sounds like it is a valid order of the court, obviously. But if there are problems with it, then there's avenues to handle that. And I don't want to get into something that I don't have all the facts on either side. So what I'm going to do is I'm going to, and you know, there's history here. There's also FTA or two, I believe I heard in his history. So I'm going to order a $3,000 surety bond. And with that surety bond, I'm going to order no further, since this did happen in November, I was going to order no further violent contact. And Ms. Robinson, would you be okay with that? Or do you want to have no contact at all?
No violent contact is fine
Okay. All right. No further
because I
violent
want to
contact.
be able to co-parent.
Okay. Well, I hope you guys can get to that place. And like I say, follow the existing temporary custody order out of Cobb County. No drugs, alcohol, weapons, or guns while on bond. And I believe that's it, since the incident location is his address, and with no further violent contact, there's nothing else that I need to order, I don't believe, at this point.
Thank you, Judge.
All right, thank you. Who do we have next?
Position number 19, Mr. Pitman.
This is 24 CR 008318Y. And this is Calvin Pitman, charged with 1 count of simple battery, family violence, 1 count of cruelty to children in 3rd degree, 1 count of battery, family violence, and a 4th count of interference with custody.
First arrest, Lebron.
All right.
Your Honor, this is an incident that just happened on the 25th at about 4:45. Police were called to 3155 Hickman Drive Northwest. The 911 call was about a altercation on scene. Police met with the victim in this case. Her name is Zuri Thomas, Z-U-R-I. The individual who called the police is named Shaquila Shanta, M-E-L-E-K-A, Malika Shanta, S-H-A-N-T-A. It's reported that the victim, Mrs. Thomas, was there at the location to exchange the child, a 6-month-old infant that she shares with Mr. Pitman. While she was trying to leave, the child was in the stroller outside. Actually, I'm not sure if the stroller was outside or inside. The child was in the stroller. She and the defendant began to struggle over the stroller. The defendant did not want her to leave with the child. He eventually removed the child from the stroller and went to a different room. Police documents state that he locked himself inside the room with the child. The witness called the 911 line and asked for help. It's reported that he threw the child on the bed and then punched mom, Zuri Thomas, in the eye. She was seen to have a laceration to her right eye. She reported that the defendant had struck her in the shoulder. This is his first arrest. This is a very small child. And we have been in touch with Mrs. Thomas today. She reports that she and the defendant are in a relationship. They share this child but don't live together, that the location is his home, and that they were fighting over the stroller. She is denying now that the defendant took the child and locked himself in a room. She says he just went to a different room, but he would not give the child back. Jail calls to this defendant's family members indicate that they were aware of what was happening when it was happening, state things to him like, well, you wouldn't give the baby back, and I knew this is what was going to happen. They were trying to give you some time to give the baby back, and you wouldn't give the baby back. Altercation like this in front of a child with very young people who don't have a clear understanding about what's appropriate and what individual rights are related to a child that's 6 months old is a cause for concern. We would ask for an SOB, Your Honor. We'd ask for that it be a $5,000 SOB. Absolutely no violence. The victim reports she's not in fear of the defendant and wants to continue contact. I would point out to the court that this child, I don't believe is a product of marriage. There is no legitimation process in the system that I've seen. And so it looks like this is a very soft agreement. And we would request that there be a requirement as part of the bond that legitimation be filed in order to gain access to custody and visitation time that's obviously wanted by this young man. But no drugs,
Well,
alcohol, no weapons, and no violent contact.
Okay. And I'm clear with the no further violent contact, although I would say that the victim seems a little indecisive about it. I understand she wants to co-parent. Advising him to legitimize the child, I'm not for sure how he was given temporary
No, this is a
custody.
different case, Your Honor.
Oh, this is not the one with the temporary.
Right.
Oh, I'm sorry, that was the previous.
It's
My
just
bad.
very similar. We have a couple cases.
Right, I was gonna
because
say
of the
similar.
holidays, but if you would
Right.
sound for the victim, her name is Zuri Thomas, and she's on the
Yeah,
Zoom. You know,
let's see.
she did minimize. That's what the state would argue at this point, the severity of this situation. I'm not sure if she's been in contact with the defendant, but
Okay.
there's some concerns.
Right. And I do. And this one, just the child exchange and the arguing over the stroller. Okay. Let's see what she says. Miss Thomas, Zuri Thomas, do you wish to address the court today, or would you like to answer a few questions for us?
Yes.
Okay, put on your camera, please.
My camera's not coming on. It keep going on and off.
I can't talk to you if I can't see you because I don't know who you are.
Give me
You're gonna
one
have to
sec.
either sign out and try to sign back in. Make sure you check audio and video to come on when you sign on.
Okay.
All right. Let's see if she does this real quick. Mr. Jordan, see if she drops out or you have to put her out and then she'll sign back on. She looks like she's still connected. Okay. If she comes back quick, we'll do it. If not, we'll go to another case and wait. There you go. All right, can you unmute yourself now? I just saw you on camera. Okay. All right, good. And you wish to address the court today, is that correct?
Yes.
All right, raise your right hand so I can swear you in. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, so what type of custody arrangement do you have with the defendant?
You said what, ma'am?
What type of custody arrangement or visitation or what's going on with you and the defendant and the child?
We's together. And
You're
that's
still
his dad.
together?
Yes.
I'm sorry?
Yes.
You still reside together after this incident on Christmas, which was just yesterday.
Yes.
And so you all were arguing over an child exchange with the stroller is what I thought the facts were.
No, the child was not inside the stroller when this happened. He was outside
Okay.
the stroller.
Okay. But you all reside together with the child.
Yes.
How long have you been together?
3 years.
And the child is the same age? Or the child is 6 months?
He's 6 months, yes.
Okay. A very small child. Are you in fear of Mr. Pitman?
No.
Do you want to have any further contact with Mr. Pitman?
Yes, because of his son.
And are you all engaged? You've not been married, correct?
No, no,
And did you call the police?
no, I didn't.
Okay. Did he?
No,
Probably one of the neighbors?
probably so.
Okay. And is this your first time having this type of
Yes.
argument? Okay. Any other questions by the state or the PD? Any other cross-examination questions?
Just briefly, Your Honor. Ms. Thomas, how old
Mhm.
are you?
29.
And Malika Shanta, was that someone who was with you yesterday?
Yes.
Who's that?
His godmom.
And did she come to the location with you, or was she already there?
She came with me.
Okay. And were you aware that she called 911?
No,
You didn't know that she'd called the police and then police came, or you knew she did?
no, because I was in the house.
Okay, so you weren't aware that she called the police?
No,
Okay. How long were you there at the location before you got the baby back?
probably like 3 hours.
And did the defendant's family come too?
His mom was already there.
Were they trying to help?
Yes,
And what room was he in with the baby?
his brother-in-law, he didn't lock his stuff in the room. He just was walking back and forth. He didn't lock his stuff in the room.
And
He just wanted the baby to stay with him for Christmas.
right, you don't live at that location,
No,
but you are together as far as you're in a relationship.
yes.
Where do you live?
I stay on Thomas Road in
And who
Riverdale.
do you live with?
My mom,
Your mom?
yes.
And have you been in touch with the defendant and his family today?
I talked to his mom today.
You were asking about how much money it's going to take to get him out.
Yes.
Did it scare you that he was acting that way?
Yeah, a little bit. But this his first time, so I never seen him like this.
You were surprised?
Yes.
Yeah. And how old is the defendant? I see a date of birth of 2003. I'm not very good at math.
He's 21.
Okay. And do you have any other children?
Yes.
And where do they live?
With me.
And your
I
mom?
have two. Yes, I have two.
Okay. And this is the only child you have with Mr. Pitman?
Yes.
Okay. And the injury that police saw on your face, you're saying that that didn't happen as a result of this incident, right?
No, it doesn't. No.
You're saying he hit you on the shoulder.
Yes, that's it. But he didn't do this on my face though.
Okay. How did you get that injury on your face?
I tripped over my feet and I fell on the carpet.
There at that location?
Yes.
While you were there waiting to have your baby given back to you for that 3-hour period?
Yes.
What was it that made the defendant give you the baby back?
Because I was finna leave and I was gonna take the baby with me. And he wanted to spend time with him for Christmas.
And so what made him hand you over the baby?
Because I let him keep it for a little longer than he finally realized to just give it back to him because he didn't want to go through this.
Because the police came?
No, he didn't. I didn't even know the police came until I walked out the door.
So you spoke to the police?
Yes.
And when you spoke to the police, did Mr. Pitman still have Chase, the baby?
No, he was in the car.
Okay. And so this incident where he was holding the baby and didn't want to let the baby go, that happened before police came?
No, yes.
Okay.
He had passed it to his mom though.
So when the police came, who had the baby?
I did.
And you had not had your baby for about 3 hours?
Yeah.
And was Miss Shanta still there with you?
Yes.
Okay. Those are all the questions I have, Your Honor. Thank you.
All right. Any cross-examination, Mr. Dotis?
Nothing further, Your Honor. Thank you, Ms. Shanta. Or
Okay.
excuse me, not Ms. Shanta.
I mean, no.
Ms. Thomas,
It's
yeah. Pardon.
Robin.
Ms. Thomas, yeah.
Zuri Thomas.
Zuri Thomas.
Yes.
Right. All right.
Your Honor, we'd
State, are
ask
you-
for no contact at this point.
Mhm.
They don't live together. This was a attempt to exchange the child for the holiday and a defendant who interfered with the custody for approximately 3 hours. And police had to be called. You just heard from a victim who reported that she didn't call the police and she wasn't aware that the police were called, but she was afraid. And there was a 3-hour period where she sat and waited for this defendant to hand the child back over that they share. There are some concerns here, not just about the maturity of the people involved, but the safety of the child, as well as family members who are obviously on scene trying to navigate this situation as well before police were called. So we would just ask for no contact that can be addressed later as time moves forward and people have a chance to adjust themselves and get some perspective on this situation. The defendant does look like he's eligible for an SOB and he's an adult. So we'd ask for a $5,000 SOB through pretrial, but no contact is what we're asking for today. Thank you.
Okay. Mr. Dotis, you have any objection to a 5,000 SOB pretrial?
No objection to that, Your Honor. I would like to speak on my client's behalf briefly. He is 21 years old. He's a lifelong resident of the state of Atlanta. He does have family support. He does share this one child with the alleged victim, and it sounds like she's not in fear. And it sounds like she wants to continue co-parenting with him. I will speak to Mr. Pitman about what he needs to do moving forward regarding legitimizing the child. I don't think that's something that necessarily needs to be addressed in the bond order, but I can let him know what steps he needs to take moving forward. As we heard, Your Honor, it does sound like before the alleged victim was even aware that police came, they were able to talk through the incident. She's saying that there were no physical injuries suffered. She wants to continue co-parenting with him. She's not in fear. She wants contact. And it sounds like they have been in a relationship for 3 years. This is the first incident, is my understanding based on what we have heard today. I just asked for the signature bond, as I think can all agree on. Any classes or courses that this court deems necessary to ensure that there's no future incidents, but we would ask that they be allowed to have no further violent contact.
All right, I'll order the 5,000 SOB pretrial. I'm going to ask that the defendant take a 1 week or 5 days of anger management courses free through pretrial. And I am toying with or reluctant on this contact. We haven't been quite 24 hours yet. I want to make sure there has been the ample cooling down period. Right now, I'm going to order no further contact. I want to see how this is going to work and make sure that parties have gotten beyond this. No further contact right now. Let's take a break and pause. And I guess that would include no visitation exchange either. No drugs, alcohol, weapons, or guns while on bond. And I guess I don't need to, well, with the no further contact, he's to stay away from her residence or her job while he's on this no contact bond.
Yeah,
Let's
will you
make
break
sure
that
it will
bond
be under.
down?
Oh, okay, for 5. Let's see, 2 on the simple battery, 500 on the cruelty, 500 on the interference for custody, so that's 3, and then 2,000 on the battery family violence. 2, 500, 2, and 500.
Thank you.
Did that add up to? I was doing my math.
It's 5,000.
And I said 500, I mean 5,000. All right. And I think that's it. Anything else, counsel?
Nothing from defense, Your Honor.
All right.
Is that a level one?
Level one, yes, I'm sorry.
Next, we go to position number 20, Mr. Porter.
And we, Your Honor, we would request that the charges here not be sounded.
All right. I will call them SB, but I usually turn off the streaming, but continue to record rather.
Yeah, I don't think there's anyone else on the Zoom, Your Honor.
Well, I should have looked at that. That is a good point. Mr. Jordan, we have all internal people, right?
Yes, Judge.